Your Lordship, I like to mention item number 7 for adjournment. In this matter, we were supposed to file affidavit in opposition, but petitioner is not here, so we could not file. So some time is needed to file.
You are for the applicant.
Applicant.
You are a government advocate.
No, I am for junior of Sunil Mao.
Item number 7.
7.
Union of India.
Yes.
PIL was disposed of. An interlocutory application has been. Interlocutory application appears to have been filed by the state.
No, we were supposed to file affidavit in opposition.
You are representing whom?
Petitioner
Petitioner. There can't be any petitioner here.
or respondent. I mean.
Item number 7.
7.
Your name is there in the cause list.
Yes.
What?
I am junior of Sunil Mao, sir.
You are a junior of me.
Mao,
Who?
sir.
Huh?
Sunil Mao.
Sunil Mao. Okay. Mao is on the respondent side. Okay. You want to file what? Objection
Yes.
on the prayer of Miss
Erai.
listed after 6 weeks to enable filing of an objection to the interlocutory application filed by the state.
Much obliged.
May I please, Lordship? Lordship, I beg to mention item number 4, Lordship. In that matter, Lordship, the learner is standing counsel, Lordship. For the education department, he is laying in the principal bench, Lordship, for some urgent matter. So this matter may be taken up on 19th.
Well, I'm for the appellant. I'm now without any place of posting. It requires urgent disposal matter. After the writ petition was filed, during the pendency of the petition, the place from where I was transferred and the order by which I was transferred has now been interfered with by this honorable court. Now I have to go back to my place, but there also somebody else has been posted. So I'm without any place of posting. So this requires an
Where
urgent
is
disposal.
Mr. Jamo?
He is in Guwahati,
And
Lordship.
Jammu, my lord,
I
I
have
am
been informed.
supporting Jammu's case, Jaipur supporting my case. So that way.
Okay, we'll take it up.
Yes, yes.
My lord, I am for the private respondent.
Ah.
The fact is, in the writ appeal, my lord have taken a view. And that writ appeal was sailed in the Honorable Apex Court,
Yes,
and Honorable Apex Court has interfered with,
yes,
and it is pending disposal there.
yes.
In that view of the matter, my lord may take a call.
I have not been able to understand what you are saying.
Yes, it is like this read petition.
My learned friend is aware of
See,
that.
just a moment. This is a transfer matter.
Yes,
All right.
madam.
Between the petitioner and must be one of the respondents.
Private respondent.
Now, transfer order was interfered with.
Yes,
That is why the appeal is.
yes.
So we'll have to.
Which appeal was assailed in the apex court.
Which
No, my
appeal
lord,
was still in the apex court?
Yes.
No, my lord, in fact, initially there was a stay in the single bench.
Yes.
Then that order, the interim order of stay was interfered with your lordship in the TV.
Okay.
The
in the
interim
TV.
order.
Okay.
Against that interim order, the writ petitioner preferred a SLP.
SLP.
So there is no bar.
After the-
as such. So accordingly.
After the disposal of the writ petition, that matter has become infructuous.
Infructuous.
Yes. So we'll take it up.
Madam.
My lord, infructuous to an extent, my lord. may not be very accurate in making the submission. For the reasons that the view of my lord has already been interfered in that read up in the SLP.
Let the matter be called up, then the clarity will come.
That's fine.
You know that everybody wants to do the case at 10:30. That is the difficulty.
Let the matter reach.
We all should have some little presence.
Yes. No, I was trying to assist my lord in pointing out certain facts.
When time comes, when the
Correct.
matter is called up.
Yes.
Deeply obliged, Lordship.
My lord, I beg to mention item number 2.
I don't know.
2.
Two.
Yes, my lord. I'm seeking adjournment for 4 weeks.
Okay, on the prayer of Mr.
B. Nyarus.
Listed after 4 weeks.
Much obliged.
May I please, my lord? And I beg to mention item number 10, madam.
Item number 10.
Yes, ma'am. On behalf of N. Sharma, ma'am.
Okay.
He is from Guwahati, madam, unable to make presence today. The matter may be adjourned today.
The relevant submissions we have not heard. What is the prayer? We could hear that you are making you are appearing on behalf of I.N. Sharma,
N. Sharma, ma'am.
and he is from Guwahati.
Yes, madam.
Yes, then
But he is unable to make presence today, madam.
okay, he is unable to present. Then
Yes. So matter may be adjourned today, madam.
as on today only.
No, maybe matter. He instructed to fix the matter on 31, madam.
Okay. 31.
Yes, madam.
Yes.
Obliged.
May I please, your lordship, in the PIL, your lordship, filed by the petitioner. Hereby, the petitioner has challenged the LPC possession certificate, land availability certificate issued by the Deputy Commissioner for different individuals in the reserve forest area. So here the petitioner has filed RTI. In response to RTI, the authority has furnished the relevant documents, your lordship. After getting the documents, he has filed several representations before the different authorities, your lordship. But in response to that representation, nothing has been taken. The grievances of the petitioner was never taken. Particularly one representation, your lordship, dated 6/2/23, your lordship. In pursuance to representation filed by the petitioner on 6/2/23, here, your lordship, the authority has the conservator of forest headquarters has written a letter to the chief conservator of forest acting upon the complaint representation submitted by the petitioner, which is I have annexed at page 287, your lordship. In pursuance to my representation, your lordship, this action was initiated. May I read, your lordship, particularly? Complaint against issuance of LPC NOC within reserve forest under Namsai district, Namsai Forest Division. In continuation of their letter, complaint letter number nil dated 6/2/22, the All Arunachal Tribal Rural Panchayat Restoration Andolan Committee, which is here petitioner, your lordship, has submitted copies of LPC allegedly issued inside various reserve forests under Namsai Forest Division as given below, your lordship. Particularly altogether 7 columns is there. in the reserve forest area, at serial number 1, Your Lordship, Manbhum Reserve Forest, Namsai, 71 number of LPCs were issued. Namsai Reserve Forest, 31 LPC. Similarly, Lordship, up to serial number 7, Khampai Reserve Forest, altogether 50.
Yes,
Uh,
Mr. Ratan.
My lord, before issuing notice, my lord, from page 41 to as many as 231, these are the LPC being challenged. My lord, these are going, if these are being set aside, this will affect the parties, my lord. And as per the Guwahati High Court PIL rules, my lord, the affected persons are even to be made parties in the PIL. Page 41 to 231.
Okay, what happened to the letter? This letter.
My lord, for that instructions will be required. Otherwise, my lord, first of all, even for instructions, my lord, necessary parties should be implemented.
No action has been taken
No, Lordship.
on this.
You are, in the last paragraph also, you are also requested to submit your action taken report within 30 days from the date of issue of this letter, Your Lordship. This was issued on 3rd March 2023.
Have you not taken instructions?
No, my lord. Instructions will be required.
There are two ways. This PL can be disposed of at this stage, directing this particular respondents to act upon this letter, if not already acted upon. That is one. And another is, as you say, that you come back with the instruction, maybe day after tomorrow.
Yes, my lord.
Whether any action has been taken on which one?
My lord, instructions in the meantime, but my lord, the respondents,
just-
affected persons will be required to be made parties, my lord.
We'll take a call on that.
And my
I
lord
think-
will see.
I think it will be better if you dispose of with a rider, as I've said. If not, if
My
not
lord will
already
see
acted
the
upon.
petitioner. Petitioner is not from Namsai also. He is from East Kamen.
It's all right, it's a PIL.
Lordship.
Yes, my lord. Even though, my lord,
If this.
these are internal communications between the department, within the department. From where this,
No, this is not internal communication. This is a communication pursuant to a complaint received from the petition
in any case, my lord.
and
That's
to find out what is what.
yes, my lord.
So this particular respondent has to act on this letter. He has been directed by the Conservator of Forest Headquarters as well as additional PCCF. So there is another direction.
Let me seek instructions, my lord. Let me-
Okay. When?
My lord, next week, my lord. Monday.
Monday. Okay. On prayer of Mr. N. Ratan, London, ANC, please take on Monday, give the date. To enable him to receive instruction as to whether the letter dated 3rd March 2023 written to the Chief Conservator of Forests, Eastern Arunachal Circle, Tezu, by the Conservator of Forest Headquarters, by number so and so at page 287, as well as the letter dated 3rd March 2023, written to the Chief Conservator of Forest, Eastern Arunachal Circle, Tezu, by the additional BCCF within bracket. What is this? Construction. And NO within bracket FCA at page 288 by number so and so have been acted upon by the Chief Conservator Forest Eastern Arunachal Circle, Tezu or not.
That's much. Obliged.
My lord. We are challenging the judgment of order passed by the single judge also. In fact, while passing the judgment of order in writ petition number 220. The learned single judge has not considered the fact that the impugn order is, which was impugned the writ petition, it was issued by Deputy Commissioner, who is not the competent authority. By that impugn order, we were directed to vacate the government accommodation that were provided to the petitioners in each sector Nahalakar. And this government accommodation is an accommodation lordship of Department of Housing. And it is only the Department of Housing who has the authority to evict the appellate.
Yes.
This aspect was not considered by the single judge.
Yes. You are still in occupation of the quarter.
Lordship, unfortunately, we have been now evicted, already evicted. But then, Lordship, we are challenging this order, Lordship. Although we have been evicted, Lordship,
Yes, what is?
since there was no interim order in this writ appeal.
May I, Your Lordship?
Yes.
Your Lordship may come to page 27
27.
by the order passed by single bench.
Yes.
It was on dated 16/5/2023. Your Lordship may come to paragraph 8, Your Lordship.
Yes.
May I read, Your Lordship? Upon hearing the parties and on perusal of the material on record, this court is of the view that there is an overwhelming public interest involved in issuing the order dated 27/4/2023. And Your Lordship, and the same reflect that there is no cancellation of any allotment, and accordingly the question of jurisdiction will not come up for consideration. At the same time, the order also reflect that necessary arrangement for payment of the rent by the corporation has been made till such time the alternative accommodation are made available to the petitioner.
What was the order challenge here?
The order challenge was Lordship, the order issued by Deputy Commissioner on 27/4/2023.
For what?
By this order, we were asked to vacate the quarters, Lordship, by the Deputy Commissioner.
All right, we'll admit. Had Mr. the counsel for, it has not been admitted, is not it?
No, Lordship.
And Ms. P. Pangu, learned government advocate. Represent all the respondents,
No, 1 and 3, Your Lordship.
1 and 3. And who is for this? 2 and 3? Yes, 2 and 4.
P. Tapo was representing Lordship.
Any standing council?
Yes, Mr.
Yes.
Any standing council for the housing? Tapu?
Yes, P. Tapo is there.
And for this chief executive
And-
officer?
Miss Karbag was also
Who?
representing these respondents. M. Karbag.
Respondent number 4.
3 and 4. Housing Department.
3, Ms. Pangu is representing Mr. Kamble. If there are no standing council, you may have to take steps.
No, they have already represented Lordship. Director Housing.
Oh, okay. See, everybody appeared on the last occasion.
Yes, Lordship.
Neither the appeal is admitted, nor notice is issued to any of the respondents. You appear for whom?
My lord, I'm appearing on behalf of Mr. Peter for respondent number 2. My
Okay,
lord, Mr. Peter is out of station, my lord.
all right. And Ms. M. Karwa, learned counsel appearing on behalf of Mr. P. Tapo, the understanding counsel for the housing department representing respondent number 2. Admit call for the reports. issue notice to the respondents. Reasonable in 4 weeks. As Mr. Ms. Palmer, Government Advocate. And Ms. M. Kavak on behalf of Ms. P. Tapu, Assistant of Health Department, have accepted notice on behalf of one and 3 and 2 respectively. No formal notice need be issued. However, requisite extra copies of the appeal may be furnished to them during the course of the day. Since Mr. S.D. Loda, London Standing Council for the Smart City Development Corporation, the respondent of 4 years had appeared on 15/6/2023. Notice on the respondent number 4, be served through Mr. S.D. Loda, Standing Council for the Smart City Development Corporation, number 4, by furnishing him a copy of the appealment or memo of the appeal. Listed after 4 weeks.
Much obliged. Well,
Yes,
I'm appearing on instruction. I'm yet to file my power in this case. File today. Below. I have filed my power.
Well, page 42 is the first transfer order. Straightway, I'm taking a lot to the order in question. Forty-two, I think.
42.
Madam.
Yes.
This was the order by which the present respondent before your lordship in the appeal and the writ petitioner. Lordship, will kindly see at page 42, serial number 6. He was transferred from Namsai as that is Government Higher Secondary School to DDSE as the Deputy Director of Secondary Education, the Porijo, Upper Subansiri. And this order was subsequently modified at page 51. In the partial modification of transfer and posting earlier order by number so dated 15th of November 2022. Sri Swenso Principal GHSS Namsai, who is under transfer to Dapurijo as DDSE, is hereby retained at GHSS Namsai as principal in the same school. Srimati Swenso is, that is the present appellant before your lordship, who was respondent in the writ petition, is hereby, he was transferred from Ligu, transferred and posted as DDSE Dapurijo. This was put to challenge, madam.
Yes.
Now, this was put to challenge on the ground, basically, that some of the ministers have recommended. In fact, it is transfer guideline. I'm not saying that I've come before your lordship for enforcement of transfer guidelines. But what I'm saying is, the finding of the learned single judge is not correct because learned single judge has held that, see, some of the ministers have recommended. It's not a question of recommendation. I have personally prayed. I have made a special request that I should be transferred to my hometown because only 6 months left of my service, madam, and for preparation of this pension papers, etc., I wanted to be in my hometown, and I made a request. Lordship, may kindly see the finding of the learned single judge, madam. Page 64, madam. 65, I'm saying. 65, Lordship, kindly see para 31.
Yes.
In view of what has been discussed above, Lordship has got panel page 65. In view of what has been discussed above, this court is of the view that having taken the decision to issue common transfer order dated 15/11/2022, the transfer of as many as 11 officers, including the petitioner, the issuance of the impugned modified transfer order dated 21/11/2022, transferring respondent number 5 to Daporizio as DDAC, singly picking up the petitioner and that too at the behest of the MLS of the district to accommodate the respondent number 5 without there being any public interest is not permissible. It is not disputed that the impugned order has been issued at the behest of the MLS of Upper Subansiri district Daporizio. Therefore, it cannot be considered that the respondent authority had applied their mind in passing the impugned order to transfer the respondent number 5 to Daporizio as DGAC and retain the petitioner as the principal GHSS Namsai, which amounts to mortgaging the decision of its discretion of its decision-making authority. This court also takes note of the fact that the impugned order dated 21/11/2022 has been passed to accommodate respondent number 5 at the behest of 4 MLS Upper Subansiri district. Therefore, the principle that a person who seeks equity must do equity applies in the present case, as the petitioner ought to have placed his grievance before the concerned authority for consideration of her genuine grievance, if any, to be considered by the concerned authority without there being any influence from the political end. My lord, may kindly see, here is a case, my lord. I have, in terms of the guidelines, I have got a right to apply, my lord. What you may kindly turn to page 101, my lord.
Yes.
Well, I'll be reading. And before that, I would like to just point out. Just a minute. Well, this guidelines says there are two types of transfer. One is in the public interest. Lord, you may kindly turn to page 96, man. It is very clear. Page 96, serial number 4, my lord.
Yes.
Page 96, serial number 4. Types of transfer. Transfer may be broadly classified into two types.
Yes.
Two types. One, administrative transfer, which the department orders suo motu in the exigencies of service and in public interest or on administrative grounds. Secondly, transfer on request, which shall be effected based on the request of a teacher and eligibility as per policy. Now, so far as eligibility is concerned, my lord, lordship will kindly turn to clause 10A at page 101. Criteria for allotment of post against a vacancy. I'm sorry, man.
Yes.
The bottom paragraph at page 101.
Yes.
Clause 9. For contesting transfer requests against a vacancy, the following parameters shall be considered for allotment of the post to the most eligible teacher. All the parameters shall carry equal value of 10 points each. Against each parameter, the employee who gets preference or priority will get 10 points, and the teacher who doesn't get preference priority will get 0 point. The employee securing the maximum score out of the total 60 points shall be allotted the vacant post. Now, one is age. The teacher who is oldest by age shall be given priority. Number 2, gender. Female teacher shall be given preference. Now, taking the, my lord, aid from this, my lord, transfer guidelines, I made a special request that I am going to retire within 6 months' time. Kindly bring me to my hometown before enabling me to take steps for preparation of this pension papers, etc. Now, on the basis of that request, my lord, they have processed also. Well, page 77. No? Page 77. My lordship, will kindly see page 77. Starts from page 73. It is not that suddenly I was sought to be accommodated. Page 73, my lord. 73 is a statement prepared, my lord, showing the process which has begun for transfer of many persons on different grounds.
I note it.
Ours is, lordship will find at page 73 itself. Page 73, down below, my lord, there is a table, and in the table, serial number 2 is the name of the present appellant, my lord. Srimati Yade Nasi, Principal, GHSS, Ligu, date of joining the present post of posting, place of posting 2020, 25th of May, tenure 2 years, place, column is meant for place where the transfer is sought as DDSC Daporijo. And then brief reason cited for seeking transfer. Joint representation of UA note from Honorable MLAs requesting for transfer and posting of the incumbent as the current DDSC Daporijo is going to retire soon. Page at 159C.
Where is your request for transfer?
Well, it is mentioned here itself. Serial number 2 at page 73, my lord. Just now I have read. My name is there, is serial number 2.
Yes.
The current place of posting place is given, next column. Then next column is date of joining there, my lord, May 2020. Then next is tenures, 2 years. And then thereafter, the column is for place where transfer is sought. Lordship has got, my lord.
Yes.
And now Lordship will kindly see. As DDSC Daporijo. This is the place where I was brought by the impugned modification order. It is not a case where, my lord, subsequently, suddenly, I have made a request to the MLA. I want to come for some other interest. I have got no other interest. I am going to retire in 6 months' time. I just want to come back to my hometown for preparation of pension papers and nothing else, my lord. And while this issue was in process, the transfer order is issued bringing the present writ petitioner to the place where I have sought transfer. This aspect of the matter was not considered by the Honorable Single Judge. Honorable Single Judge is thinking that I have challenged some transfer order and I have brought here by a pick and choose manner, etc., etc. The issue is different.
Request was submitted to whom?
To the authority, my lord.
Which authority?
Secretary.
Huh?
Secretary. My lord, this is a note of which department.
All these were pleaded case in the writ petition?
Yes, ma'am. Yes. No, I am for the private respondent in the writ petition. This is my pleaded case.
Oh, okay.
I am for the private respondent. This is my case is very simple. I do not want transfer for any other purpose. I don't have any place of choice for, like I want to go here, I want to go there. The writ petition, Lordship will kindly see visualize one thing. The writ petition has been transferred. Normally, a person, whenever he is transferred from one place to another, he doesn't want to go. He puts a challenge. Here he goes and joins.
In the affidavit, you may have stated that?
Yes, yes, ma'am.
Okay. Counter affidavit?
Yes, yes, ma'am.
That you have
That is,
made a request to the secretary?
my lord, yes.
You have made a request to the secretary?
Yes, yes, ma'am. That is the only case I have before the Lordship, my lord. And that is why, by an interim order, your Lordship was pleased to stay the interim order passed by the learned single judge earlier. And as against which they are saying that they preferred SLP. SLP is pending. So my request was there already, my lord.
Oh, what is this SLP business?
SLP, I am just clarifying what has happened. When this order was modified, bringing me to Daporijo where I actually sought. By modifying the transfer order by which the writ petition was brought to Daporijo instead of me. Lordship has got my lord.
Yes.
Now, when the Honorable Single Judge stayed by an interim order the modification order against me, I preferred an appeal before the division bench. The Honorable Division Bench, my lord, stayed the order passed by the learned single judge.
Okay.
As against that, an SLP has been preferred by them. It has lost its efficacy, my lord, when the writ petition itself has been taken up. And my lord, I am just now told that while the writ petition was taken up, the other side said that my lord, no, it's different. Their honorable, this court expressed a view that when the SLP is pending, should we take up and all? They said no, it can be taken up. Now they are saying it cannot be taken up. My learned was there. I'm told when I was not there. Anyway, these are small things. These are not on merit of the case. So this is the position. My lordship may kindly see my affidavit. Where is my affidavit? Page 83, my lord. My affidavit starts, my lord. Where I was scheduled to be.
Yes.
My lord may see page 84, paragraph 4. page 84, paragraph 1. While replying to my paragraph 7, 8, 9, and 10, I have said like this, that as regards the statements made in paragraph 7, 8, 9, and 10 of the writ petition, the answering respondent states that the petitioner has been posted at Ligro Higher Secondary School since the year 2007. And presently, the answering respondent is on the verge of retirement in the month of February 2024 on superannuation. As such, the petitioner approached the leaders of Upper Suburban District and requested them to appeal for the transfer and posting of the answering respondent to Daporijo. That the answering respondent states that there is a policy of the state government to transfer the officers to headquarters to facilitate the preparation of the pension papers. That the answering respondent states that in the instant case there was only around 1 year remaining for her superannuation. As such, she advanced such requests to enable the preparation of her pension papers at her home district. That the answering respondent states that Ligro Higher Secondary School is located at Kamle district and is at a distance of around 5 to 6 hours, and the road condition is pitiable due to ongoing road cutting and construction works. Situated thus, she opted to retire from her own home district of Upper Subansiri. That the answering respondent states that when her request for transfer and posting to Daporijo in Upper Subansiri district was not considered, she again approached the department, now my lord, the department, and requested for transfer to Daporijo in terms of the policy guidelines for transfer and posting of teachers in Arunachal Pradesh. That the answering respondent states that apart from transfer on administrative grounds, transfer of teachers can be made on request as well, which I have stated, my lord. That it is further stated that as per the transfer policy and guidelines, the oldest teacher and a female teacher shall be given preference while filling up the post. It is also stated that as per the transfer policy, a teacher shall be posted at a school for a minimum of 3 years. In the instant case, the petitioner has not completed the said minimum of 3 years. As such, on the approach of the answering respondent and upon considering the balance of convenience, the earlier transfer order was modified and the answering respondent was transferred and posted from Ligro Higher Secondary School at Kamle district to Daporijo in Upper Subansiri district. This is my case, my lord. Very simple. And my lord, what I am saying, my lord, if the writ petitioner is not opposed to his transfer from Namsai, he should go to any place this Honorable Court directs or the department says. He shouldn't have a choice, but I have a choice because that will be my home district and I am going to retire. This aspect of the matter was not taken into consideration by the Honorable Single Judge. That is my submission before Lordship.
Yes. What is the age of the appellant?
59. She is retiring in February 2020. February 24.
59.
Yes. February.
Yes.
And one more aspect, my lord. In the meantime, the authorities has passed another order on 12th of May, by which the place where I was posted earlier as principal has been filled up by another person. So there also I cannot go back. And that person has joined on 16th of June. That is why I couldn't bring it to the notice of this Honorable Court earlier. I have brought it to the notice of this Honorable Court by this appeal. Lordship will kindly consider my lord.
My lord will kindly come to page 108.
Yes.
The order of the division bench where my lord have interfered with that particular order.
Stay order passed by the single judge was vacated.
Right.
Vacated.
Right.
It was assailed
So,
in the Supreme
yeah.
Court,
Right.
which is still pending.
It's pending. Then secondly, my lord will kindly come straight to page 115.
Hmm?
Page 115.
115.
Second last paragraph.
Yes.
My lord has, while interfering with that stay order, my lord is given a liberty to the single bench to proceed with the matter. It says, we however make it clear that dependency of this appeal shall not be a bar for the learned single judge to finally adjudicate the writ petition in question. So by virtue of this order, the honorable single judge has decided this matter.
Which is under challenge.
Yes, but in the meantime, my lord, this particular order passed by my lord has been assailed in the form of SLP before the Honorable Apex Court. That is the only point which, my lord, as a duty-bound court officer, I was referring to.
That SLP has become infructuous.
No, but then still it has not been disposed of.
Correct.
No, I'm pointing it out, my lord, because my lord also.
All our judgments will be subject to the scrutiny of the appellate court.
Correct, my lord. That is no more res integra. my lord.
Our orders are not final unless tested before the last court. Then where is the
And I-
disqualification for this court to take up this matter?
No, I am not raising this, my lord.
Okay.
I only has
Just
informed
pointing
this
out.
court as a duty bound officer,
All right.
saying that my lord might kindly take a call only to this aspect. Then my lord has
Take a call means?
take a call, when the matter is in
Yes,
session
yes,
of the
we pass
Superior
order.
Court.
Yes, we pass order.
Yes, my lord. Then we close this chapter. my lord. We close this chapter because
I thought there is something.
no, my lord, there is nothing as such because we feel it appropriate that we should not suppress anything.
Order we passed today also
Correct, my lord.
is subject to be tested.
Further
before the appellate.
challenge.
Whoever is agree, we go to the
Yes.
appellate court.
No, we skip that. my lord.
That is the beauty of this judicial procedure.
Yes.
The senior counsel has clearly submitted not only the beauty, the facet of the judiciary, my lord, where we tested ourselves whether our actions are correct or not, my lord, till the last appellate court decides it. My lord, we'll come to page 53, the impugn order being assailed. I seek the indulgence of my lords to page 67. One particular paragraph. However, in view of the fact that the respondent number 5 is on the verge of retirement, the respondent authorities may pass appropriate order posting the respondent number 5 to a place where she may not face any hardship in the preparation of her pension papers. Now, my lord, my fair submission would be, if my learned senior friends agree to the proposal, let this matter be remanded back to the authorities to take a call. In view of his submission that the place where she has been displaced with, a new person has been posted, let the authority take a call if she can be adjusted somewhere without interfering with this impugn order. Now, in view of this paragraph 35,
Whether you will agree?
no, I am making a submission that while interfering with the impugn modified order, my lord, the learned court has come to a conclusion at paragraph 5, giving a liberty to the state respondent to pass an appropriate order so as on the fact that she is on the verge of retirement, the respondent authority may pass appropriate order posting respondent number 5 to a place where she may not face any hardship in preparation of her pension papers. But two things, my lord.
She will not face hardship if she is posted as DDSC Dapolism.
That is my lord's decision. I am nowhere to interfere or try to influence my lord.
What she will say. Court is not saying so.
No, therefore, my lord,
Okay.
ultimately, it is the executive who is going to take a policy decision on this. And taking under 226, my lord, the Reed Court may not venture into the domain of the jurisdiction of the executive in taking a decision, my lord. And that would, if we travel beyond that, my lord, it would be nothing but assuming the jurisdiction of the executive by the judiciary, my lord. So therefore, my lord, only on this count, my lord, let the state authority take a decision. And pursuant to those orders, my lord, I have already joined, assume the charges, my lord. My lord, the instruction as of now that I got is that this impugn order was rendered on 36/2023. And pursuant to that, my lord, I have already joined on 3rd July, my lord.
It's 15 days in the office that I am discharging, my lord. Appropriately, my lord, my fair submission would be kindly remand this matter back to the authorities to pass an appropriate order whereby and whereunder she can be.
By setting aside the judgment of the learned single judge.
No,
Then how the authority will take a fresh decision in the matter unless that order is set aside? Authorities will be bound by the order of the learned single judge.
that is what I'm making a submission on the paragraph 35 of the impugned judgment rendered by this single bench.
To post the appellant in some other place.
No. That their guidelines, my lord. There is one judgment I forgot, my lord. Any employee who is on the verge of retirement, if falls within a period of 1 year, she should be given a place of she should be posted at her choice if it is relating to the preparations of the pension papers and all. I forgot to bring that judgment, my lord. Number one. Number two is that, my lord, in terms of the guidelines also, there is one rider in that guideline.
No, Mr. Tara, we could have passed the order which you are asking for.
Hmm.
But the appellant wants to be a daporism, where you are already there.
Therefore, my lord, in terms of this paragraph 35 of this order, why not this honorable court, with all humility, I request to remand the matter back to the authority so that they can do the rezugging of the places where she also can be accommodated at Daporij or either nearby the places. my lord.
But daporism, there is only one post of DDSC.
That's why I'm saying.
So including the place, including as a DDSC daporism.
But headmaster and the DDSC is the same this thing.
Well, one aspect I would have agreed. I am otherwise senior to him, my lord. Now, if I work as a principal, I'll have to work under him. And another thing, my lord, another thing I'll just indicate. This is one. Another thing, my lord. He has got 4 years of service left. Let him do some more teaching. I have done all throughout my career teaching. Now, as a DDSC, I'll be holding an administrative post. That much of relief, my lord, my client is paying as a lady teacher, my lord. The whole career she has served.
There is no quarrel on that, my lord. The DDSC and
Today, what they want is I should work under him.
No, sir. That is unfair submission.
You can wait for a year. She is going away after.
No.
Just 6 months.
My lord,
If February-
6
my
months.
lord, 6 months.
No, my lord, I am on
After
one.
that, let him come. Lordship, my lord, this is a very fair, my lord, very nice suggestion from the Honorable Court. If I work for 6 years, if your lordship indicates to the authority that after 6 months he will come and join here, he also gets the benefit of coming here.
Senior has a special place in all
No,
aspects.
so
of
that
One practical difficulty my client has expressed, my lord, from the place where the school is, where she is residing, to the headquarters, she has to travel 4 or 5 kilometers, which is absolutely horrible. Now, for preparation of pencil papers, again and again, she will have to visit that. This is another difficulty, practical difficulty, my lord.
my lord,
I am going to retire, my lord. This is one submission you lordship can consider, my lord.
my lord, I am sticking
When are you
to
retiring exactly?
February
February 24, 2024.
24th of February 24, my lord. February 2024.
Yes, 6 months.
Only 6 months.
Yes, my lord. Therefore, my lord, I am sticking to the order, the paragraph 35 of the impugned order. Because the learned single judge has committed no error for the reasons that it has given an opportunity to the state respondent. So therefore, in view of this paragraph 35 of this judgment, it is a duty cast upon the appellant to approach before the appropriate authority to kindly have a look into this paragraph 35 of the judgment. One. Number two, my lord, DDSC and principal post are analogous. Therefore, the question of
senior or junior working in whatever place will not come into considerations at any relevant point of time. Now, my lord, kindly come to the guidelines which they have provided. Page 93 is the type copy of the guidelines.
Yes.
It says, no officer of group A and B should be posted in his home district so that he does not develop vested interest. Now kindly come to D also. Officers are not to be transferred 1 year before the retirement, as it may affect preparation of their pension papers. However, generally, officers posted in the field work division should be posted out to officers headquarters 1 year before the retirement. Now, my lord, it is no more a res integra as well that transfer and posting guidelines has no statutory force. My lord. These are a guiding documents that where a policy decision can be taken. No, my lord, in the best, I agree to the proposition by the senior counsel to an extent that I am on the verge of retirement and I am left with 6 months of period. Be that as it may, my lord, we have to follow the rule of law as well. My lord. The personal difficulty that will not come into if the appellant is taking shelter of this particular guideline, my lord, then the guideline A and B comes into force. So therefore, my lord, I give a final proposal. Let them file one appropriate application before the state respondent to take a decision in this regard.
These guidelines of 1998 has been now dispensed with by the new 2020 guidelines, number 1. And Lordship will kindly have a look at the judgment passed by this on the Justice Thagia earlier, where there was a I've just given one judgment where earlier there was a challenge to a similar modification order, and incidentally, my learned friend was there and supporting the modification, unlike the present case. There, your lordship has held, I'm just reading paragraph 18 and 19. 18 and 19. Paragraph 18 says, it is again a well-settled position of law that insofar as a judicial review of an order of transfer and posting is concerned, unless the order is shown to be issued in the mala fide exercise of power or is issued in violation of any statutory provision and is not issued by a competent authority, an order of transfer and posting cannot be interfered with. Accordingly, in the absence of any mala fide or exercise of power by the respondent authorities or violation of any statutory provision in issuing the impugned order to so by the so, I am therefore not inclined to interfere with the impugned order, which is a modification order, my lord. And here there is no
There he
lord,
on the case.
supported that, my lord. In fact, my lord, here in this case, on the single judge, I mean, my humble submission.
This order was passed on the basis of his arguments.
No, the fact is,
But he is entitled to make a counter submission in a different case.
no,
I am not saying that. I am not on that matter. What I am saying is, my lord, in this case also,
That
there is
why-
no,
Yes, sir.
in this case also, my lord, there is no allegation that the order of modification was mala fide. It was clearly a case of request made by us. This aspect of the matter was not taken into consideration. That's my submission. What we kindly consider.
my lord, the fact in this case, which the senior counsel has referred to, where I argued in that matter, the fact is a bit different.
Yes, yes. Fact is-
The fact
yes,
is a bit
facts are
different. The judgment is rendered on a different principle. Here, it is a case of a request. On the request of the appellant, my lord. On the request of the appellant, which one? And therefore, the public interest does not include and does not come into it.
After 6 months, let it come and join here.
Mr. D. Mazumdar, Council, Senior Counsel for the appellant. Assisted by Mr. D. Shoki, Government Counsel. Mr. P.T. Tara, Government Counsel for the respondent number 5. Anybody is appearing for
Mr. Jamo is not there, Milord.
all right. None is appeared for the respondents. 1 to 4. This intra-court appeal is directed against the judgment in order dated 36/2023 passed by the one single judge in WBC 461/2020. However, the impugned order of impugned order dated 21st November 2022 passed by the Commissioner Education, Government of Arunachal Pradesh by Minister at page 164. Modifying the earlier order of transfer dated 15th November 2022. Insofar as the appellant and the respondent number 5 are concerned, thereby posting the appellant as DDSC Daporizal has been interfered with. Admin, call for the record. Issue notice to the respondent. Yes, Mr. Tara, Ranat Council has entered appearance and accept notice on behalf of respondent number 5. No formal notice need be sent. The steps for service of notice, none. Respondents 1 to 4 shall be served through the Standing Council for the Education Department, Mr. T. Jamo. Start on the interim period. The respondent number 5, who was working as a principal GHSS Namsai, was posted as DDSC Daporizal, Upper Subansiri District as DDSC by an order of transfer and posting dated by order number 14/2021 dated 15 November 2022 issued by the Commissioner Education, Government of Arunachal Pradesh, internal by number sense at page 42. The aforesaid order of transfer dated 15 November 2022 was modified by order number 15/2022. Where dated, did I say dated? Issued by the Commissioner of Education, Government of Arunachal Pradesh by number so and so, wherever the respondent number 5 was retained as principal GHSS Namsai, and the appellant was transferred and posted as DDSC Daporizal in place of the in place of the respondent number 5. While interfering with the impute modification of the impute order dated 21st November 2022 issued by the Commission on Education Government by Itanagar, the learned single judge by judgment and order dated 30/6/2023, passed in WPC 461/2022. In paragraph just a minute. In paragraph 19 and
31.
31 or 32?
31. 31.
Okay, and 31. It has been recorded as on the both paragraph 19 and 31. Full stop. From the above on perusal of the reasons assigned by the learned single judge in paragraph 19 and 31 of the impugned judgment. Did I say the reason assigned? Okay, the reason assigned by the learned single judge. You read like this. On perusal of the paragraph 19 and 31 of the impugned judgment and order of learned single judge. It transpires that the impugned order of transfer dated 21st November 2022 was interfered with by the learned single judge on the ground that the order of transfer dated 21st November 2022 was issued on the recommendation of MLA only, or there was a member of minister also?
There is one.
Four MNS.
Okay.
One minute.
On the recommendation of minister and the members of legislative assembly of the Upper Subansiri district. Full stop. Paragraph. Assailing the impugned judgment and order of the learned single judge, it has been contended that the appellant was it has been contended that though it has been contended that appellant was transferred and posted as DDSC Daporizon on the basis of teachers transfer and posting policy 2019-2020 within bracket education, which was notified on 10th February 2020 by the Secretary Education Government of Arunachal Pradesh, whereby in addition to the administrative transfer, the transfer on request is permissible, and when transfer on request is made, priority is given to the teacher who is oldest by age and priority is given inter alia to the teacher who is oldest by age and the female teacher. Full stop. In the instant case, it has been contended that the appellant is a female teacher aged more than 59 years and due to retire on 24th February 2024.
Not the particular date, but February 2020.
Okay, in the month of February 2024. Whereas the respondent number 5 is aged about 51 years.
56.
About 56 years.
Okay, about
4 years of service left now.
okay, about 56 years. Also, the appellant therefore contends that the learned single judge has while passing the appeal judgment in order had overlooked the opposite transfer and policy, transfer and posting policy of the government followed in the education department. Also, we have perused the notification dated 10th February 2020, which is a teachers transfer and policy, transfer and posting policy 2019-2020 within bracket education, which is followed in the Department of Education in so far as the transfer and posting of the teachers are concerned. Because on perusal thereof, we notice that there are two types of transfer. One, administrative transfer, and another transfer on request. Post of transfer on request is effected based on the request of the teacher and eligibility as per the policy. Post of the policy further prescribes that in a transfer made on request, age of the the teacher who is oldest by age and female teachers are given priority and preference. Also, there is no dispute in the instant case that the petition that the appellant is a female teacher and aged more than 59 years, whereas the petitioner, sorry, the respondent number 5 is stated to be aged above 56 years. In that view of the matter, we find that in the impugned judgment and order dated 30/6/2023, passed in WPC 461/2020, there is no discussion that the one is single judge about the transfer and policy of the teachers in the education department notified on 10th February 2020.
My lord, I would only request, my lord, kindly bring it on record. Paragraph 35 of the impugned judgment by this learned single judge, yes. What I am making a submission is that the opportunity has been given to the appellant in one way, that we are directing the respondent authorities, the executive,
to take a decisions in view of interference of this order. So the first place, they ought to have approached the respondent authorities to consider the paragraph 35 of the judgment. So my submission is, without exhausting this,
See,
and
Mr.
honorable court
no, Mr.
coming into the conclusion,
Order of the learner singular is in two parts.
agree, my lord.
First part is the learner singular has allowed your writ petition.
Correct,
Set aside her posting as DDSC.
correct.
Second part is he had made some observation. Despite that, she may be posted in a place where no inconvenience is caused to her, which is distinct from her claim that he should be posted as a DDSC Daporizm. So this part, they are not agreed with. They are agreed with the honorable learner singular where it is, her posting as DDSC Daporizm has been set aside.
No, my lord, still, I request only, I can only request, my lord. Kindly bring it on record, this particular paragraph.
Saying what? He is on the budget of the respondent or may pass approval posting the respondent to a place where she may not face in a hardship in the.
And therefore, my lord, on the basis of this, let the executive take a policy decision where she has to be accommodated.
We will pass the final order in the month of August. We are just admitting it.
No, my lord, even then, my lord, kindly bring it on record, my lord. This cannot be skipped to my understanding, my lord. This particular paragraph. my lord.
Okay. At this stage, what is to be, okay. At this stage, Mr. T.T. Taral, counsel for the respondent number 5 has submitted that the learner single judge in paragraph 5, or sorry, 35 of the impugned order has observed that since the respondent number 5 stock appellant hearing is on the verge of retirement, the respondent authorities may pass appropriate order posting the respondent number 5 to a place where she may not face any hardship in the preparation of her pension papers. And accordingly, he submits that the appellant should have approached the respondent authorities.
To exhaust the remedy. To exhaust the remedy and allowing the respondent authority.
Seeking appropriate posting of the appellant where she may not face any hardship.
Correct.
Okay. Post.
The second aspect was, I have already joined personally.
We have not yet completed our dictation.
We are just, I apologize for
Okay.
interfering. I'm
Anyway,
just
you're
pointing out.
welcome, yes.
Yeah.
Any other things to record?
The second point that pursuant to the impugned judgment and order, the petitioner has already joined on 1st July.
Okay.
And in discharging the duties.
Mr. Tarafa.
3rd July, sorry, 3rd July.
Respondent 5 further submits that pursuant to the impugned judgment and order of the learned single judge, the respondent number 5 has already joined as DDSC Daporizm on 1st of July.
3rd of July.
Huh?
3rd of July.
3rd of July.
3rd of July. sorry.
3rd of July. Full stop. In addition to the finding recorded here in above, that the learner single judge, while passing the impugned judgment and order, had not taken into account the teachers transfer and posting policy 2019-2020 dated 10 February 2020. We also find that the sole ground for interference of the impugned order of transfer dated 21st November 2022, as can be gathered from paragraph 19 and 31 of the impugned judgment order is that the order of transfer dated 21st November 21st November 2022 has been interfered with solely on the ground that the same has been issued by the respondent authorities on the basis of recommendations made by the members of Legislative Assembly of the Upper Subansiri District, thereby mortgaging the conscience of the respondent authorities. Full stop. Not full stop, comma, which in our view is not in consonance with full stop. The recommendation made by the members of Legislative Assembly are all stated to be from the district of Upper Subansiri. Therefore, the interference made by the learned single judge to the transfer order dated 21st November 2022 solely on the basis of the recommendation of the MLS may not be in consonance with the law laid down by the Honorable Supreme Court in Mohammed Masood Ahmad versus State of UP and others, 2007 8 SCC 150, wherein the Honorable Supreme Court has held that the recommendation made by the local MLS and the members of parliament by itself may not vitiate the order of transfer. Also, the concerned MLS and the MPs being the representatives of the people, it is their duty to ventilate the grievances on behalf of the people. Also, there cannot be any hard and fast rule that every transfer at the instance of an MP or MLA would be vitiated. First off, it all depends on the facts and circumstances of an individual case. First off, paragraph in view of the above, we therefore are of the view that the learned single judge appears to have prima facie committed an error of law in passing the impugned judgment and order dated so and so in WPC so and so, thereby interfering with the transfer and posting order dated 21st November 2021 solely on the ground that the said transfer order has been issued on the recommendation of the members of the Legislative Assembly, who admittedly is stated to be local members of the Legislative Assembly of the district. In that view of the matter, till the returnable date, the impugned judgment order dated so and so in WPC so and so passed by the learned single judge shall remain stay. Please state in the month of August for hearing.
Well, we can we have a quick? Well, we would like to have a quick sir. Kindly give your date.
After 4 weeks,
No, we
there is an urgency because a person has already joined and working person to that, and which my lord have interfered. Let us decide on merit, what is there, what is.
Of course, we'll decide it on May. After 15th of August. Any date, any
No, no,
date convenient to the person.
16,
Huh?
16,
16 August. Okay, 16 of August.
yes, grateful. Deeply.
Wait, my lord, here notice upon the respondent number 2 is complete.
Hmm.
Matter will be fixed for hearing.
Okay,
It's a criminal appeal.
paperwork is also there. Hard-
Paperwork is there.
The following are accounted for the appellant is removed on an APP. Which is been submitted on an accounting for the appellant that respondent 2 has also been served. And the paperwork has been taken in view of the above, this is appeal for hearing in due course.
Obliged.
Lord, I am praying for disposal of this matter today. I'll not take much time, Lord. Lord, the fact of the case is that the petitioner was suspended. And
The authority has requested for further some more time to file affidavit. The department, we are yet to file our affidavit lawsuit.
This is an appeal.
appeal, my Lord,
Because lawsuit, the read petition that was disposed of in motion stage itself lawsuit
Oh, without an affidavit.
without any affidavit. So therefore, this honorable court lawsuit given us some time to file affidavit lawsuit.
no, my Lord, then in that case, that there
Otherwise,
should be a
lawsuit-
stay. Let there be a stay.
Otherwise, lawsuit.
This
the
is not
proper
permissible in
legal-
law.
Otherwise, the legal issue lawsuit, that is whether there can be extension beyond the lawsuit 90 days when the charge sheet or lawsuit charge memo is not filed lawsuit. To that extent lawsuit, we can have a argument lawsuit. But if the merit of the case is to be touched lawsuit, the requiring the facts of the case lawsuit, then in that case lawsuit, affidavit would be required lawsuit.
His case is that the
Milpetato, my Lord, I completely relied on Milpetato's judgment rendered by Lordship, wherein it has been held that if this delinquent officer is suspended and within 90 days, if charge sheet is not filed, then the subsequent order is a choice in law, my Lord. And that, my Lord, in that Milpetato judgment is the case where my brother Tapin has also appeared. And this was the longest, long time argument in this case. We had a long argument, 5 days, my Lord. And finally, it boiled down where Ajay Chaudhary's judgment was clarified, and pursuant to Ajay Chaudhary's judgment, my Lord, the Milpetato judgment was rendered.
that notification still applies.
Applied,
It still applies lawsuit.
Huh?
Yes,
Yes,
Then notification appears to be clear.
Lawsuit,
very clear.
notification is clear lawsuit, but notification has been issued in terms of the Ajay Chaudhary's case lawsuit. Now, what Ajay Chaudhary's case says,
You have understood Ajay Chaudhary in the manner you have notified.
lawsuit, to my understanding, because we have to examine the lawsuit correctness also lawsuit. Because on the page lawsuit, that memo lawsuit has been issued lawsuit not in terms of the Ajay Chaudhary, but by lawsuit by Mr.
No, Tapin, I'm giving you, paragraph 2 of that OM
Because
2016, my Lord. On the basis of
the
Ajay
correct
Chaudhary
meaning
judgment.
of the Ajay Chaudhary case lawsuit, that has been lawsuit misconstrued lawsuit, and then this memo was issued lawsuit.
No, see, after that notification,
Lawsuit.
it is not Ajay Chaudhary which will determine.
Lawsuit.
This is the notification which will determine.
But lawsuit, the law, that notification cannot supersede the laws if law laid down in the Ajay Kumar Chaudhary's case lawsuit.
But see, correct. But you have issued such a notification, which you yourself say that this notification has been applied and followed to your employees.
Lawsuit, when lawsuit, the OM itself has been issued by misconstruing the lawsuit, the
No, it is, see,
No,
Had
you
you-
cannot take a different
see,
stain on
had
this.
you said so, this Milpetato judgment would not have come. You categorically admitted that, yes, this is the notification.
Correct.
Which is followed by the government insofar as the suspension case of the employees under you is concerned. The judgment is based on that.
Lordship, in Mirpur Tatu's case also,
Now,
Lordship.
today also you are not denying it.
No, in Mirpur Tatu case also, Lordship.
Huh?
Rather, I objected to this OM, Lordship. On the account, Lordship, this OM, Lordship,
OM was not a part of the record.
it was not the part of the record, Lordship.
You see,
In
just
the last moment, it was placed before this court, Lordship. Only I was asked to, Lordship, collect instruction, whether it applies to Honest Pradesh.
yes, you have been instructed.
Yes, Lordship. It applies, Lordship.
Paragraph
It's
6.
issued by the central government, Lordship.
And rightly you are following CCA rule. So
No,
therefore,
we are not on
the
Lordship.
notification issued by the Ministry of Department of Personnel is applicable in Arunachal.
Okay, when will you file?
Lordship, I may be given 3 weeks time, Lordship.
Then stay, Lord, kindly stay this. Because this is not, this judgment is not on the basis of a sound principle of law.
Let us give them another 2 weeks time.
No, Milord, kindly, this is against the principle of ratio decidendi, Milord. If it is to be disposed of in that manner, Milord,
You are under suspension
I am suspended under suspension.
for APPSC case.
Yes, Milord.
You wait for some time.
No, Milord. Well, the thing is that the scheme occurred even before I was posted. And in the charge sheet which the CBI has filed, I have made as an official witness. My involvement is not there. I came later part. Well, only to that extent, kindly interfere only to that extent, the charge sheet has not been filed within a stipulated period of 90 days. And then the Mirpur Tatu judgment has not properly been appreciated, quoted the wrong paragraph of the judgment below.
What affidavit you will file? Affidavit, if at all to be filed,
Lordship.
it has to be with regard to that notification.
It's regards to Lordship, how Lordship this extension has been made, Lordship.
Extension has been made.
Extension, we are not disputing. Even you may have,
Charge sheeted.
Charge sheeted.
No, he has been
No,
charged.
extensions of the Lordship.
Extension of
that's-
suspension.
Suspension.
I forgot that also, Milord. I will stick to one point only.
But your notification says something else.
Lordship, therefore, Lordship, suppose say, let's pose a question
I
to
think my
ourselves.
brother Tapin is not here
When,
today.
Lordship, there's a law in one hand, Lordship.
Huh?
If there's a law in one hand, Lordship, in other hand, Lordship, the OM, Lordship. When these two are contrary to each other, Lordship.
We will not allow you to function in this manner. You will befool your employees with a notification, which today you are submitting that it is not in accordance with the law of the land. On that day, when the Mirpur Tatu case was heard, you said, yes, this is the law.
Lordship.
We will not allow you to function like
We
this.
cannot blow hot and cold, Milord.
Lordship-
Otherwise, if he's aggrieved, the state is supposed to file appeal against this judgment.
If you want to deny the notification, you file an affidavit, categorically denying it. It will not be on your submission. You have already submitted. We will not allow you to make a contrary submission, which is already a part of the decision of this court. We'll give them 2 weeks time.
Well, Milord,
See,
in a
this
read
kind of a
appeal,
submission will not tolerate, but since he is saying something.
well, in a read appeal, what kind of affidavit is required to be filed?
Lordship, my submission is the same only, Lordship. In earlier also, Lordship, I have submitted, Lordship. This
My lord,
OM
kindly-
is not in
my lord,
terms of the Ajay Kumar Chudhary this
Milord,
case.
my,
No.
In this, in Mirpur Tatu's case also, I have submitted the same thing, Lordship. So for the applicability of this OM is concerned, that has been
Mr.
admitted by
Tapin,
the state
you-
Lordship.
you-
This is applicable to the state
Mr.
government,
Tapin, you have forgotten what you have submitted. It is a part of the record.
Lordship.
You read again. As the office memorandum dated 23/8/2016 was not a part of the pleading, Mr. Tapin, London senior government advocate, was handed over a copy of the said office memorandum to provide him an opportunity
para 6.
to receive instruction from the respondents whether the OM dated 23/8/2016 produced by the London Council for the petitioner is applicable to the employees of the state of Arunachal Pradesh.
Correct, Lordship.
Today, not correct, not only correct.
Lordship.
Today, Mr. Tapin Lana, senior government advocate on instruction received from the respondent authority submits that the said office memorandum dated 23/8/2016 is applicable to the employees of the government of Arunachal Pradesh, and no subsequent office memorandum have come to the light of the state respondents superseding the OIM dated 23/8/2016. Now, what else do you require? No
Lordship,
opportunity given, no, what can, no, it's not in accordance with law.
Lordship. Here also, Lordship, I have submitted, Lordship. So the part the applicability is concerned, Lordship. That is not disputed, Lordship. What I'm submitting is the Lordship. This OM is not in terms of the Ajay Kumar Chaudhary's case, Lordship. And the law laid down in Ajay Kumar Chaudhary case has to be applied.
This kind of submission will not allow. Then we'll take it up today or when? No evidence is required. Yes, you will apply notification to some employee and you will not apply to this person. That is the kind of submission you are making.
No.
You will apply to Murupatato, you will not apply to Suraj Guru. What is this? On the prayer of Mr. S. Tapin, Learned Senior Government Advocate. For the
May not we,
2 weeks' time is granted. for filing of the complaint.
we go for a shorter date. This is not to be interpreted in that manner. Today is 17, no? Will not be, can you try to accommodate on 27?
Okay, let's do it on 27.
27 will be.
No.
If
I'm
Lordship is-
sorry, no, this is, please don't make that kind of submission. This is not fair.
Yes. Next.
May I plead with your Lordship? Well, in this criminal appeal, we are challenging the judgment and order dated 09/12/2020. Passed by the special court, Kunsa. The accused has been in the judicial custody for almost 2 years and 6 months. Well, in this writ appeal,
POXO case.
yes, my lord. Yes, your Lordship. POXO case, your Lordship.
Proceed with the hearing.
He used to come from Guwahati, could not come today due to some personal difficulties. The matter might be adjourned at least after 3 weeks. I have informed the other side of.
Yes.
I am officer respondent only, private respondents are there.
What is this matter? Emma?
This is promotional matter, Lord.
Promotion.
Yes, Lord.
On the prayer of Mr. B. Typodi,
On behalf of,
Learned Council on behalf of Mr. P. J. Saket,
yes,
Learned Senior Council for the appellate. Listed after 3 weeks.
yes,
Lordship, I am for 11 to 15 on.
Hard miss GAT. So. Yes, for the respondent number,
11 to 15
okay, 11 to 15.
applies.
nice.
The election of the respondent number one written candidate from 44 Teju ST Assembly constituency in the election held pursuant to notification number 18, notification dated 18/3/2019 is hereby declared void under section 101B, 101D1 and 4 of the Representation of the People Act 1951. The election petition is allowed to the extent indicated above and is on disposal.
Meantime, my lord, file one IA under 116B that may be finally taken up tomorrow
What is that 116?
for suspension of today's order. In the meantime, so that we can file appeal under 116A.
We can
I-
take it up tomorrow.
Tomorrow.
There is provision.
But there is a provision, but since he has filed an application, instead of tomorrow, can it be taken up next week on 16th? I'm coming. Tomorrow I'll have difficulty, I cannot stay.
When did you file?
Today only copy served.
Today file? Did you know that the election petition would be allowed?
No, just it's been filing now.
Huh?
Copy is served, it is under filing now.
It will be listed in due course.
My,
We can't say anything.
my,
So unless you know the election petition
Anyway,
is
in that case,
allowed,
it will be listed tomorrow only. madam.
you had no confidence in your defense.
That is not the case, but then anyway, we have to be always
You have
ready.
filed, there is statutory provision.
Huh.
It will come up in usual course. We'll take it. up.
Highly always.
may I please know, sir?
Lordship, on behalf of Tagum Jamo, Standing Council, Education Department, I beg to mention item number 2. In fact, he is there at Guwahati in principal seat. And he will be coming back tomorrow only.
Which item?
Item number 2. And item number 2. I am told that Lordship, he has received the instruction as well as the records.
Just a moment. Item number
Item number 2.
2.
Yes.
Oh, yes. First item. Yes, Mr. Tama.
Item number 2.
Yes.
Let the matter come.
In fact, I have the instruction to mention on his behalf, so why I am mentioning Lordship.
Perhaps he was supposed to take instruction in this
Yes.
matter. So shall we list it tomorrow since he is not there?
He'll be coming back tomorrow, Lordship. He will be attending court day after tomorrow, Lordship.
Tomorrow,
He has,
I'll be having some difficulty. This week, I'll be having some.
But in this, okay, let the matter be called up.
Let the matter.
My lord, I have filed 4 IAs relating to publication of notice in the newspaper, that is substitute service. And the main cases are listed today in item number 16, 17, 18, and 19. So this matter will be hard to get along with the main case number today.
Okay.
My lord, if I may pray for listing of a pending writ petition for orders tomorrow, my lord.
What is that?
Well, the matter pertains to non-payment of bill, PDS bill,
And as per the last order, it was supposed to be listed. as-
Affidavit filed.
Perhaps, my lord. I have not gone through the records from in the
Then
office.
if the affidavit is not filed, what order can we, what effective order can we pass?
It was,
See, affidavit is filed or not, you have to know.
yes.
Other, they can't file an affidavit without serving you a copy.
As per the,
Okay, anyway,
my
not-
lord,
not tomorrow, day after.
tomorrow, my lord, if possible. Orders.
Or
May I, my lord? My lord, item number 25, my lord.
25.
Yes, my lord. I am on behalf of T. Gade, my lord.
Hmm.
So this matter may be fixed on 21, my lord, this Friday, my lord.
What is the matter about?
This is about the compensation, my lord,
Which compensation?
for damaging some trees and some plantation, my lord.
Okay, after, not 21. After 2 weeks,
My lord, fixed date requirement,
Huh?
fixed date requirement,
31st of July.
31st of the, much of
Okay, on the prayer of Mr.
T. Kamchi.
T. Council for the petitioner.
Yes, my lord,
Listed on 31st of July.
much of it.
Where I like to mention item number 6.
6.
Yeah.
Yes,
My lords, I behalf of the Tapak. So
what is the matter about?
appointment of MTS.
Appointment of?
Here is case lordship, appointment of MTS lordship, private respondent appointments lanes.
APS.
MTS lordship.
M-
Multitask.
Multitask.
MTS. Okay. Let the matter be called up. Let us see what for it is listed.
Matter may be released after 4 weeks.
You wait, when the matter is called up, we'll pass order. You make a mention at that time. Yes,
May I lordship, I would like to mention item number 26 lordship.
26.
Lordship, the petitioner lordship, she doesn't want to proceed further this matter lordship.
Huh?
For withdrawal lordship.
You want to withdraw the writ
Yes,
petition?
lordship. She don't want to pursue this matter further. lordship.
Okay. Mr. Jiva,
Yes, lordship.
then the counsel for the petitioner. An instruction. Fix to withdraw this writ petition. Also, writ petition. Stands dismissed on withdraw. Also, the interim order parcel, if any, stands vacated.
No, there is no any interim lordship.
All right.
Myself.
May I please, your lordship. My lord, I beg to mention item number 10, your lordship.
Yes,
Lordship, kindly the matter may be listed on 21 August. Lordship.
21 August.
Yes, your lordship.
Why 21 August? Today is, it has been listed as fixed by an earlier order.
He was coming.
What is the matter about? Any urgency?
No, your lordship. As instructed by S. Pandey, your lordship.
On the prayer made on behalf of the council petition listed of the 8 weeks. If there is urgency, make a mention.
Yes, your lordship.
May I please, my lord? My lord, I beg to mention item number 7, my lord, on behalf of Mr. Peter Ho.
Ah,
My lord, Mr. Peter Ho is out of station, my lord. The matter may be
you
taken up.
wait, what is the matter about?
The matter is about the minimum pay scale, man. The petitioners are seeking minimum pay scale wage or at par with the regular employees.
Affidavit filed.
Yes, your honor.
Have you informed the other side?
Yes, my lord.
When do you want?
Next week, my lord.
After a week, okay. On the prayer of, have you informed the
Yes,
other
my
side? On the prayer of Miss M. Carver, Lamet Council. For the, on behalf of Mr. P. Tapu, and the Standing Council of Apex Bank,
Yes, my lord.
listed after 2 weeks.
Fine. Deeply.
Yes.
In this case, my lord, instruction, it was sought from the Standing Council Education Department.
Yes, this instruction will be required. Who can be appointed as residential school coordinator?
My lord, that day while arguing, both of us on the same line. That is, there is a notification of 14/9/2006, which my learned friend, standing counsel, he said that that is obsolete now, done away with. But then my learned friend, standing counsel, he agreed with the 9th executive meeting, wherein guidelines for appointment of coordinators in any intervention that he admitted. That is at page 24.
Where is that?
Page 24, my
Yes, page 24. Serial number, close.
clause 12.
This is.
The executive committee has approved for appointment of BRC CRC district coordinators for different interventions. So coordinators, residential school is one of the intervention, my lord. From teachers with sound academic background, only 10 years teaching experience with B.Ed diploma in elementary education.
Yes, this is the instruction which we wanted.
Yes, my lord.
That district coordinators for different intervention
My lord.
includes residential school coordinators.
Coordinators.
Let there be some more clarity. Day after tomorrow you will appear.
Yes, Lordship, as instructed by the standing council.
In that
Education
case, my
Department,
lord,
he
may I
available-
pray that matter may be taken up on 26th.
26.
This week, I'll be. And in the meantime, my lord, caveat may be discharged. They have filed caveat. They may also file affidavit.
No, affidavit. We have not yet issued notice here. Huh? You are saying that the private respondent is not eligible to be
My lord,
transferred in your post,
my lord.
isn't it? That is what we are trying to gather
Okay, my lord.
by our instruction. 26.
26, my lord.
So, Mr. K. Town, and Mr. Yes, sir. The council on behalf of Mr. T. Jamal, Standing Council for Education Department, who prays for an adjournment of this case on the ground that Mr. Jamo is out of the station. Who prays for an adjournment of this case and for this and for listing of the same on day after tomorrow is what? Give the
Wednesday,
day after tomorrow.
19.
19.
Yeah, okay, 19. So had Mr. T. Garam, then council, which respondent?
Respondent number 4, Lordship.
Respondent, no, had also T. Garam, another council respondent. Having, in view of the adjournment sought for on behalf of Mr. T. Jamal, Standing Council for the Education Development for the listing of this matter on 19, Mr. Tamar on council for petition has submitted that let this matter be listed on 26th.
My lord.
26th of July, on which date? Okay, post. As petrol listed on 26th of July, on which date? The State Council will produce the necessary instruction as directed. Shall produce the report is called the instruction received from the department as to who can be appointed as a residential school coordinator as directed by the 12/7/2023. Please take a look.
Highly understood.
Yes, I mean,
Yes.
what happened in this case, my lord? I participated in NIT, my lord. According in term of that, my lord, I was awarded a work, my lord. Now I have completed 50% of the work, my lord. Now what the respondents are saying, my lord, the work
amount, my lord, involved in the work was 5 crore, my lord. Now they are saying that they will limit that is into 50 lakhs only, my lord. That I am agree, my lord. I'll indicate, my lord, that start from my lord, page number 38, my lord. This was the sanction order, my lord. Page number 38, my lord. My lord.
There's no 38.
38, my lord. Section number 3, my lord. My lord will see, my lord, the governor of Arunachal Pradesh is pleased to accord administrative approval and expenditure sanction not exceeding a sum of 50 lakhs only against the estimate cost of 500 lakhs for the project, my lord. Construction of ecotourism at Jasir Tabia village not been ordered, my lord. Now, in terms of this, my lord, page number 40, my lord, is the NIT, my lord. NIT was issued, my lord, column number, my lord, 4, my lord, will find, my lord, estimated cost of the tender was, my lord, 4 crore 62 lakhs, my lord. I participated in this NIT, my lord. Now, in terms of that, my lord, page number 51, my lord, 41, my lord, section number 5, my lord. The relevant will be 42, my lord. This is the agreement, my lord.
Page number
42, my lord.
41.
40, you start from 41, my lord. Relevant will be 42, my lord.
Yes.
42, my lord. This agreement was drawn, my lord.
Between you and the respondent.
Yes, my lord. Respondent, my lord.
Yes.
My lord will see, my lord, third para, my lord, whereas cost is 4,57,308, 457 lakhs 38,432, my lord. Now, in terms of that, my lord, I have started the execution of work, my lord. I have completed 50% of the work, my lord. Now, my lord, may kindly turn to page number 54 directly, my lord. 54,
When was it signed? 26/11/22.
22, my lord.
Yes.
Page number 54, my lord. Annexation number 8, my lord.
54.
This is, my lord, by the Secretary Tourism, my lord. May I read this, my lord? To the Executive Engineer, PW Sangram Division, Government of Arunachal Pradesh, recast modification of detailed project report against the project construction of ecotourism village Jasa, Tabiang village, Nyaping Kurung Kume district. I am to inform you that due to constraint of fund provision in the Department of Tourism, Government of Arunachal Pradesh, you are hereby informed to modify the detailed project report against the above mentioned project from 500 lakhs to 50 lakhs only, my lord. Now, situation, I have already agreed 50% of the work, my lord.
This is impugn order.
Impugn order, my lord.
Impugn letter.
Yeah, my lord. I'm praying, my lord, crossing of this in my lord, consequential order, my lord, directing the respondent by to adhere with the agreement, my lord, dated 26/11/2022, my lord. Now, against this, my lord, I have tried to buy representation also, my lord. Representation at page 55, my lord, I have submitted, my lord.
Yes, Mr. Any other impugn order? There appears to be another impugn letter.
No, my lord, still, my lord, as my representation yet to consider, my lord, there is no other impugn order at this stage, my lord. I am impugning this letter, my lord.
What is this 20 October by the Minister of Tourism? You are asking for setting it aside also? Or you have forgotten?
20, my lord, this is, my lord, letter, my lord, you or not, my lord, my lord. That may be not get you or not, my lord.
Then why have you written here? Yes, please.
My lord, first of all, whether the petitioner can claim as a matter of right that the project should be implemented or not. If the government wants to scrap the project, it can do so. If there is any breach of agreement, he will have to approach the civil court, my lord. There is, of course, an agreement. Till now, no decision has been taken.
But how could you have written this letter at all?
My lord.
How could you have, how could this
But
respondent have written?
these are changes, maybe in the changes in the policy of the government. My lord. If they wanted, if they have thought that it was over budgeted,
Okay,
government can always review.
government can always review.
Yes,
But
any
here,
project.
what you have done is, you have invited NIT for 5 crores. He participated, you settled the tender with him for 4 point, etc.
Yes, my lord.
crores. He started the work. He has invested 2 crores now. Now you want to restrict it to 50 lakhs. So for the works he executed, so far, 2 crores, now you will restrict it to the 50 lakhs. And the government can well do it.
My lord, he will have a remedy to claim for damages for the loss he incurred. Because it is a contract. If the government.
Okay, Mr. L. Parmel, counsel for the petitioner. And Mr. M. Ratan Lamed, AAG, for all the respondents.
Yes, my lord.
For all the respondents. This petition is directed against the letter dated 16 December 2022. Written to the Executive Engineer PWD Sangram Division, Government of Arunachal Pradesh, by the Secretary Tourism, Government of Arunachal Pradesh, by number at page 54. Whereby DPR against the project within inverted comma, construction of eco-tourism village at Jacha within bracket Taviang village, Nyapin, Kurungkumi district, inverted comma close. Have been and not have been, which was prepared for rupees 500 lakh, has now been informed to modify it to the value of rupees 50 lakh only due to constraint of fund provision in the Department of Tourism. Full stop. What is the NID?
Page number 40, 40.
The petitioner's case, common in brief, is that where pursuant to sanction order dated 17 July 2022, issued by the Secretary Government of Arunachal Pradesh, Secretary Tourism Government of Arunachal Pradesh, according administrative approval of expenditure sanction not exceeding a sum of rupees 50 lakhs only against the estimated cost of rupees 500 lakhs for the project within inverted comma construction of eco-tourism village at Jacha, Kaviang village, Nyapin, Kurungkumi district, phase 1 at page 38. And NIT, what is the date? NIT date?
Page number 40, my lord.
Date is not legible. What is the date?
Date, my lord. 15/9 to 15/9, my lord. 15/9 2022, my lord.
And NIT stated to be dated 15/9,
2022.
2022 at page 40 was issued by the executive engineer, Sangram Division PWD, inviting seal item rates tender for construction of ecotourism village at Jacha, Pavyang village, Nyapin, Kurkume district, phase 1, for an estimated cost of rupees 462 lakhs. Pursuant to which was full stop. In pursuance to the petitioner's participation in the aforesaid tender, an agreement dated 26/11/2022 was signed between the petitioner and between not the petitioner, between the executive engineer within bracket client stock engineer in charge bracket close Sangram PWD division and the petitioner's firm for execution of the ecotourism village, etc., at the cost of rupees 4,57,38,432 at page 42. It is the case of the petitioner that pursuant to the aforesaid agreement dated 26/11/2022, the petitioner has executed about 50%.
50%.
About 50% of the work, thereby investing how much of money?
Investment, my lord, I'm not sure, my lord.
Okay, 50% of the 50% of the work. Also. Under the circumstances, the petitioner submits that limiting the cost of the aforesaid project to a 50 lakhs rupees only by the impugned letter dated 16 December 2022 written to the executive in the PW Sangha by the Secretary of Tourism Government of Himachal Pradesh does not extend to reason. Yes, in the event the same is in the event the said project is restricted to 50 lakhs of rupees, the petitioner would suffer great loss and prejudice in monetary terms.
My lord, my submissions, my lord. I will have only
Mr. M. Rathan AAG for the respondent submits that it is the prerogative of the government to restrict the cost of the project. It is the prerogative of the government to vary the cost of the project at any time as per the wish of the state government. Yes.
if there is any fund constraint, my lord, and I'd like to show, my lord, agreement was entered and the date of commencement of the project was 25/11/22. This impugned order is not even within a month, my lord. At page 43 is the date of commencement of the work, my lord.
25/11/22
Is the date of commencement of the work and the decision to reduce the DPR was of 16th of December 2022. Within only 1 month,
Let us find out what is what.
Yes, my lord, that may be also recorded, my lord, that
That I have
by
explained.
by execu-
Mr. N. As a part of submits that the though the agreement was agreement between the though the agreement between the executive engineer and the petitioner was signed on 26/11/2022, and the same was given effect to from 25/11/2022. The letter restricting the cost of the project to 50 lakhs is only of 16 December 2022. What do you want to say?
my lord, just by after knowing that the costs have been reduced, my lord,
Having heard the learned counsel for the parties.
and one more submission, my lord,
Let notice of motion be issued, returnable in 4 weeks. Yes.
one more submission, and if there is any breach of contract,
Hmm.
the petitioner will have
He further submits that if the petitioner suffers any loss,
breach of contract.
okay. Okay, all right, then he further submits that if there is any breach of contract, the petitioner can always approach the civil court.
This one.
Having heard the learned counsel for the parties, let notice of motion be issued, returnable in 4 weeks. 6 weeks. So, as Mr. Ratan, he has entered appearance and accept notice on behalf of all the respondents.
Not all, my lord, 1 to 8.
1 to 8. Who else is there?
9 is the minister.
Okay. 1 to 8, no problem. Is there support? For service notice upon response will be taken by both years within a week. Full stop. On consideration of the contentions raised by the petitioner, as above, we have the counsel for the parties in the interim till the returnable day. Impugn letter dated 16 December 2022, written to the executive engineer PWD Sangram, Government of Andhra Pradesh by the Secretary Tourism Government of Andhra Pradesh, returned by the number so and so shall not be given effect to. This
But my lord, the returnable date may be within 3 weeks, my lord.
6 weeks, what is there?
Then the status quo, my lord, because if they continue with he continues with the work and then claims, that can also not be allowed, my lord.
Then we'll send them, you said that.
My lord, that rider, because just because the contractor keeps on proceeding with his work, that also will not.
It's a, though the notice has been made returnable after 6 weeks. In the event the state respondents filed their counter affidavits before 6 weeks, the matter shall be listed as soon as the counter affidavit by the petitioner.
Work may not be proceeded, my lord. That will be amounting to.
Counter affidavits by the respondents are filed.
My lord,
Mr. Ratan, we appreciate your anxiety and your promptness to dispose of the writ petition, but you find out for yourself whether the government files the affidavit within.
My lord, work may not be proceeded, otherwise it will be indirectly giving them a license to continue with the work.
Not license, they have already given me, my lord,
No, my lord.
my lord. The
See,
issue,
see,
my
it
lord,
has been restricted, my lord.
even the issue raised by my lord.
Now,
I
just
can answer now
because
also.
he completes some work, now he will be claiming that that can also not be allowed, my lord.
This court has prima facie found the action of the respondents to be absolutely arbitrary.
Yes, my lord.
You have consciously prepared a DPR for 5 crore, invited NIT, awarded the work for 4.5 crore. Now, after he has started the work, you restrict it to 50 lakhs.
My lord, that
Why not 20 lakhs?
my lord, that if
Yes,
the
yes,
government,
yes.
it is always in the prerogative of the government, my lord.
I have recorded.
Otherwise,
That prerogative
Any-
can be
any-
always
any-
tested
any
tested under
project-
Article 220.
Any project, the government can
That
even
prerogative, my lord,
scrape
can
the,
be tested by this
project,
honorable
my lord.
court, my lord. That's the issue, my lord. They have prerogative, my lord, and this honorable court had the power to test
Government
that
can
prerogative.
even scrape the entire project, my lord. Any loss he suffers can be reclaimed.
I'm
Can
sorry,
you
my
not-
lord, additional advocate, my lord is making such a address submission.
Yeah.
Can we not pass order against the respondents?
Of course, my lord can, but my lord can also observe, my lord, that continuation of the work by the petitioner will be at his own risk, my lord.
The Mr. After the order has been dictated, Mr. N. Ratan Lanet, Additional Advocate General for the State of AP, has vehemently argued that petitioner may not be allowed to continue with the work. Full stop. I am not inclined to accept the prayer made by the Lanet Additional Advocate General on the ground that the action of the respondent authorities after having prepared the DPR for the project so and so for the for an estimated cost of ₹5 crore, and after an NIT was floated, and having selected the petitioner, and having awarded the work to the petitioner to petitioner the said work for an estimate for a cost of ₹4.5 something crore. And signed an agreement dated 26/11/2022, thereby allowing the petitioner to commence with the work, and just after about a month of the ongoing work, restricting the project of 5 crores to only ₹50 lakhs have been found to be an action on the part of the respondents, which is most prima facie most arbitrary. Full stop. Please take it away.
Always.
Yeah, please, Your Lordship. Lordship, this case, the petitioner has been compelled to approach this honorable court, Your Lordship, because the state commission is not functioning, Your Lordship. An award was passed against the petitioner in the district forum. He filed an appeal within the statutory period, Your Lordship. However, the state government, now the Union of India, has appointed the president after Justice H.N. Sharma retired from the post. He was the last person holding the post of the president. Now, after he retired, no one has been appointed and the appeals are pending. And during this time, though I filed the appeal within the statutory period, the appeal is yet to be heard. I filed it on 2/12/22. And till date, no sitting has been held of the state commission because of the absence of the president. And in the meantime, the execution proceeding and the Bakijai proceeding has been initiated against me, Your Lordship.
Which is the order which has been challenged in the appeal?
The order which I appealed against is of 19/10/22 Annexure F, Your Lordship. The type copy, Your Lordship will find at page 58, Your Lordship. The original is at page 56. The type copy is at page 58, Your Lordship. If Your Lordship has got it, Annexure F.
Yes. Yes, 58.
Page 58. Now,
What kind of order is this?
this was the order I have appealed against, Your Lordship. And that means in this order also Your Lordship will find, because why I appealed it, because as per the Act, if there is any defect in the product, it is to be sent for an analysis. Now, here the trial court, the district forum, without getting for that and without taking evidence, nothing was done. On the ground that the report could not be produced, the court closed the matter and decided the matter without taking any argument or taking any evidence, Your Lordship. There was no hearing, no trial was conducted in the entire case. It is a mandate of law to that if there is a defect in the product, the court is to require an analysis from the experts. No, there was no expert. First, they sent it to the DTO.
Where is the appeal?
The appeal, Your Lordship will find annexure G, page 60, Your Lordship. And the filing of the appeal, the acknowledgement that we filed the appeal has been issued by the State Commission at page 77, annexure H. That is the receipt memo from which we had filed it. The receipt has been given, and a number has also been allotted to the appeal, Your Lordship, A/1/22, Your Lordship, and we filed it on 2/12/22. Now, from 2/12/22, I am before the statutory authority, but because of the inaction of the respondents 1 and 2, I am unable to proceed with this. Now, I have no other option but to come because the district forum has already initiated the execution. Even the respondent number 2, the DC, who is also the certificate officer, has started the Bakijai proceeding against me on the basis of the complaint of on the basis of the judgment, Your Lordship. So we are in nowhere, Lordship. We approached the appropriate forum. In para 13 of this petition, I have specifically stated our rights of the statutory means fundamental rights are being violated because of the inaction, Your Lordship, specific statement. Because we are not saying that this honorable court will have to decide the matter. We are asking the respondent number 1 and 2 to at least appoint the presiding precedent so that the appeal can run its natural course, Your Lordship.
In the absence of state forum, can you not take it to national forum?
No, that is an appellate forum, Your Lordship.
No,
Any
that's
order from this, then only we can go there. This is the writ jurisdiction. We cannot go to the National Commission without any order from the State Commission, Your Lordship. Because
the state, see, you have come here because the state commission is not there.
because this is the writ court has the power to direct them to appoint the respondents, to appoint a president with regard to that, you know, at least protect this, you know. And that is the limit of the jurisdiction of the state commission. National Commission does not allow bypassing the State Commission, Your Lordship. Means that is a problem we are facing.
Yes, yes, okay.
Means till such time the president is appointed, no coercive action on the basis of the forums should be initiated, Your Lordship. Because my whole purpose of if the execution proceeding is finalized or the Bakijai is finalized, my appeal becomes infructuous, Your Lordship.
Lordship, today, Lordship, let notice only go, Lordship.
See, we have no,
Where is that?
see,
I-
there appears to be no state forum. state
Yes,
communal forum.
that's the fact, Lordship.
And it is not like, it is not also likely to be set up immediately, constituted immediately. In the immediate future.
Lordship.
But there is no option that to stay this.
In that case,
No
Lordship,
question.
yes, Lordship, in that case,
The
Lordship, if-
moment it is constituted, it will be sent back there.
Because without the president, the quorum is not there, Your Lordship.
Actually, applications were invited, none had applied. There was, earlier there was no this
Yes.
invitation application.
Yes.
Now this government is change of application. So nobody applied.
yes, Lordship, Lordship also.
Now, not only our case, Your Lordship, so many appeals are pending. And
No, not many appeals are there.
from the district forum, Your Lorship.
I've been informed, not many appeals are there, but Whether appeals are not many or that's immaterial, there has to be.
Yeah, Biswas. My name, Lordship, next day, my name may be shown in the cause list. My name has
Not so. Yeah, Mr. Learned Counsel for the petition. And Miss
Lordship, I'll be for 2 and 4 only.
2 and 4.
Yeah, 3 is the main effect, the main respondent here.
Yeah, this.
Complainant, I mean.
3 is the complainant, I think.
Yes, he
Yes,
is the
3 is complainant.
And Union of India is number 1, Your Lordship.
2 and 4. Anybody for Union of India? This. This petition has been filed by the petition. Contending that though an appeal under section 41 of the Consumer Protection Act 2019 has been filed by the petitioner on 2/12/2022 against the order dated 19/10/2022 passed by the District Consumer Dispute Redressal Forum, East Siam District, in ESCD case number 01/2021. But the appeal filed by the petitioner has not yet been heard because the State Consumer Redressal Forum has not been constituted. Because of the non-hearing of the appeal filed on the petitioner against the order dated 19/10/2022 passed by the District Consumer Dispute Redressal Forum. The order dated 19/10/2022 is sought to be executed.
Pardon, Your Lordship.
This order passed by the district forum is sought to be executed by the
Or respondent.
Yeah.
by the district
Yes,
forum only. Execution is done through
yes,
district forum.
by the district forum, but he has directed the respondent number 4 to initiate the Bakijai proceeding, Your Lordship. Your Lordship will find annexure J, Your Lordship.
Okay. Annexure J.
And a latest order passed by the district forum, Your Lordship will find that annexure N, Your Lordship, whereby they are saying that we are not obeying the order.
Page number?
Page number 93, Your Lordship.
No.
On one hand, they have directed the respondent number 4 to initiate the Bakijai proceeding, and on the other hand, they are proceeding so moto on their own with regard to punishing the petitioner, Your Lordship. Before the Bakijai, we have appeared and filed our objection under section 9 of the Bengal Recovery Act, Your Lordship.
Page 93 is the latest order.
93, Your Lordship, is the type copy of the annexure N. This is the order passed by the district forum recently, fixing 20th of this month to be the date when they are going to pronounce adverse order against us, saying that we are willful violator of this. But prior to that, they had directed annexure J, Your Lordship will find the annexure J at page 84, Your Lordship will find that they have directed the DC to initiate.
Okay, that's because of the non-hearing also, the order dated 19/10/2022.
This one.
Passed by the district consumer access authority is sought to be executed by the respondent authorities. By the respondent authorities. Issue notice returnable in 4 weeks.
Lots of.
As Ms. Patel, additional senior government, enter on 2 and 4. No formal notice be sent. Extra copies of the writ petition be published behind during the court of the day. Notice on respondent number 1 be sought through the DSGOY or CGC. The steps for service on notice of respondent 3 be taken by the state proceeding as the usual process within a week. In the returnable death. In the returnable death. No coercive action shall be taken against the petitioner pursuant to order letter 19/10/2022 passed by the District Consumer Dispute Redressal Forum District Pasigan in ESCD 01/2021. The Binam Messer versus Ghost Brother Auto Sales Private Limited at page 58. Listed after 4 weeks. By showing the name of Mr. A. Biswas. On a counsel for the petition in the cause list.
Worship, the proceeding in these two cases may be stated, the specific numbers may be mentioned, Your Lordship. Proceeding in the two cases. The numbers of the cases, one before the district.
I have said no coercive action shall be taken against the petitioner pursuant to the order passed by the district forum. Because
Extra-
all those orders emanates.
It will be marked, yes. Highly obliged.
Extra copy.
Extra copy, yeah.
Yes.
Yeah, please.
Yes.
In this writ petition, my lord, these petitioners are agreed with the impugned order. It is at page 27, my lord. Twenty-six, my lord.
26.
27 is the annexed copy with this 26 order. Annexure 3, madam,
Yes.
dated of 2nd December 2022. To the Deputy Commissioner Kurungome District, Kolorian, subject issue of press armed license regarding reference to your letter number so and so, so and so. Sir, with reference to the above cited letter, I am directed to inform you that the order number PSH 6 2000 so and so dated 23/8/2030, copy enclosed for blanket ban on issue of press arms is still in force. As such, your request for issue of press arm license is regretted. Now, coming to next phase, my lord. This is the order dated 23/8/2030. Whereby, my lord, state respondent, they have imposed complete blanket ban on issue of press arm license. My lord, since arms, ammunition, and explosive.
Why do you need arm license?
My lord, yes, because kindly come to page.
This is without jurisdiction.
Without jurisdiction, my lord.
Okay, we'll examine.
My lord, may kindly come to page. Anyway, my lord, 23, my lord.
23.
23, my lord.
Yes.
This is the letter written by the Deputy Commissioner to the Secretary Home, dated 10 November 2022, my lord. To the Secretary Home so and so, subject recommendation for issue of special arm license to private individuals of border areas under Kurungame District under special relaxation 17 onwards. Reference our letter number so and so. Sir, in reference to your letter by number so and so dated 22/6/2022, a minute of joint coordination meeting was held at Huri ITBP, that is Indo-Tibetan Border Police Border Outpost BOP headquarters on 20th September 2022. The copies of the minute of the meeting are enclosed here. The Panchayat Raj leaders and village Gamburas raised the necessity of armed license for self-protection, and all the military and paramilitary officers too supported and recommended the necessity of issuing armed license to the porters, sardars of the border
patrolling troops. A list of identified photo troops, sadars containing serial number 1 to 70, wherein our names are there, my lord. From border areas, along with prescribed format of undertaking for issue of armed license is submitted herewith.
Petitioners are porters.
Porters, my lord. So considering this aspect, my lord, this letter it was submitted, that was denied, my lord. Whereas, my lord, in a similarly situated case, this honorable court has already disapproved the action impugned here in this case, my lord. That is at page, my lord.
What kind of arms you require?
SBBL, that is there in the list, my lord. Kindly come to page 24, my lord.
Yes, there is no uniformity.
No uniformity.
Some
Or some .28 rifle, some SBBL gun, some .306 rifle.
So that itself indicates that the porters, why do they require arm license, these porters?
Because necessity in the border area, sometimes they have to help the patrolling troop also in guiding
To
the,
fight with the Chinese.
not Chinese, but then the requirement may arise so tomorrow. So therefore, considering all those aspects, even the Gamburas and paramilitary, this ITBP, they have supported the cause. That in fact, they are entitled, they are eligible to be having armed license, my lord. So other than this aspect, my lord, this honorable court has already, my lord, disapproved the impugned actions herein, my lord, in this case.
This license,
Other than that, my lord,
no, see, after this license is issued,
my lord,
you will buy the gun for yourself or the department will provide?
no, for myself, my lord,
For yourself?
for myself. Other than this, that aspect also, my lord,
Oh,
since
it is a letter with the deputy commissioner.
deputy commission,
Deputy commission is of the view that the porters require.
he had a consultation meeting with the village Gamburas and the ITBP officers. Thereafter, on their recommendation, I mean, ITBP police personnel also, they have said, since these porters sometimes help us in locating the areas in the border area, so they need to possess arms. So if possible, they may be provided with arms. So accordingly, considering that necessity, the deputy commissioner has written this letter to the secretary home. And my lord, impugn order, my lord, because my lord, arms, ammunition, explosive, my lord, as your lordship is well aware, that comes in item 5 of union list.
But why do you require arm?
Necessity, my lord, it is
Necessity. What is that necessity?
this letter of deputy commissioner, my lord, speaks.
I think arm license should be issued after 2024. After the general election, isn't it? Now everybody will now have to deposit their arms now. Till the election is there.
That time is coming.
For the petition.
Otherwise, my lord,
Will issue notice.
my lord, this order of this honorable court, my lord.
Which one?
Kindly come to page, my lord, 50. So many writ petitions earlier it came up before this honorable court.
Yes.
So by order dated 24/8/2022, this order it was passed. Page 50. The Act of 1959, that is Arms Act, my lord, provides for a legal right to the citizens.
That is all right. Then what was directed here?
In this case, actually, my lord, the issued armed license in between the period 2017 to 19, that was cancelled and that was put to challenge. And that was cancelled because relying on this 2013 blanket ban armed license. So pendency of that, when that was enforced, you have.
So this court has held that the state has no authority to cancel. Is not it? It is only the Union of India who can cancel. Something like that.
My lord.
Something like that. So that is all right. But here, you want an arm license
my lord.
to be issued by the authorities.
Ah.
We'll examine whether you require.
That is, my lord, my legal right is held by this
Ah,
judgment also, my lord.
right to be
Because-
considered,
Right to be considered.
right to be considered. They have
So-
not denied it.
My lord may only,
On what reason they denied it? You have shown one letter that the ban is still in.
In
Ban
force.
is still
But
in
then
force,
that-
which apparently is according to you.
not
Not-
in force, not in force, not
sustainable.
vacated so far the, by any further notification. But this honorable court has already held it redundant.
Now, just a moment. What is the nature of employment of yours as a porter?
We used to carry the,
It's a permanent employee.
not permanent.
Moment
Of
you
course.
get the gun license, you will leave the job.
No, my lord, those,
We'll examine entire aspect. It's
If-
not that simple.
so only, my lord,
If
only,
you are entitled to, you definitely get. But
my
have
lord,
some
only
cases-
one issue whether district magistrate is the competent authority to issue license or not.
See, see. It is not only of the porters,
My lord,
it is the right of every
every
citizen
citizen,
under the Arms Act
my lord.
to consider for an arm license. But if you seek license by virtue of you being a porter
My lord,
and posted at a border area,
my lord.
that necessity will be determined by the employer. And once the employer decides that, by virtue of a porter, you require a gun license. The gun will be provided by the employer, not you. See,
No, my lord, ITBP, they are not authorized to provide us with the
that's what I'm
arms,
saying.
my lord.
That's what I'm saying. Now, this police personnel are provided with a gun. Why? They are required. Who determine? Not the individual police personnel. It is the department which determines which police post will require what kind of a gun. And they are provided officially.
My lord, in that case, slightly differentiating myself. Had it been, my lord, since I have applied for arm license in a proper application. So let us forget about I am a porter. Still, my lord, being a citizen, I have a legal right to have arms to be considered my case. So therefore, only issue will be tomorrow also whether district magistrate.
You
is-
want the matter to dispose of today?
No,
That's what you should notice. It's only a gun license. You are not dying of
Since-
hunger.
since my lord, already this honorable court has
See,
Disapproved.
this court has decided the validity of the ban imposed.
my lord,
You know, beyond that, this court has not decided who is entitled to, who is to be issued gun license within how much period of time.
my lord.
All those are there.
My lord, if it can be done through instruction, if the state respondent comes up with instruction that district magistrate is not competent to issue the gun license, then we can go ahead with the matter, my lord.
I don't find any urgency in this position. We'll examine it. You appear for all.
Yes, ma'am.
Mr.
1 to
Ketan,
5 are all officials.
counsel for the petitioners, and Mr. R.S. Naval, ASG, for all the respondents. We should notice, we turn over in 4 weeks. Extra copies.
Highly obliged.
Yes. You wanted an adjournment in this case. You have got a petitioner. Yes, what is the matter, Remo? Miss Basar? What is the matter, Remo?
Lordship, Lordship, this
You
matter
are-
is dealt
you
by
are
the
from whom?
Mr. I am for the private respondent, Lordship. This matter is dealt by the standing council, Lordship. Tawatakun.
Okay, health department.
Yes, Lordship.
Yes.
Appointments, challenging the appointments of private respondent, Lordship. 5 and 6, Lordship.
5 and 6.
Though, Lordship, my our appointment lordship. From the 25 persons from the contingency staff lordship, as per the recruitment rules lordships.
Okay, all
And-
right, all right.
I'm
Main,
appearing for respondent number 4, your lordship.
main respondent is the health department.
Health is also there, your lordship.
Okay, all right. Well, adjourn the matter. When?
After 4 weeks.
Mr. B. Civil and counsel for the petitioner who press for an adjournment of the case. Also, Ms. R. Russell, and government advocate for respondent number 4.
4, your lordship DC.
And Mr. G. Bang, and counsel for respondent number 4 and 5.
5 and 6 lordship.
Oh, sorry, 5 and 6. None appears for the health department. The common respondent 1, 2, and 3. It appears that the appointment of the respondents MTS staff
Yes, MTS.
in the health department is under challenge. First of change allowing the Senate council of the health department is also not present today. That this matter will be listed after 4 weeks as paid for by Mr. Swenson and council for the petition.
May I please, Lordship? Lordship, as per the order sheet, respondent number 8, that is a private respondent, was supposed to file their counter affidavit.
Tatak is for 8.
Yes, Lord.
You will not file affidavit.
I have been informed that the work has been already completed. And then.
Oh, this is NIT matter.
Yes, Lord.
Tender matter,
I think in process.
Yes.
in progress. Perhaps minor.
So if you.
I've been waiting for the last 3 years for their affidavit, but now it seems the work is completed.
So if you agree,
In
we'll
an-
close this matter.
My lord,
Mr. T. Jamu, SK Jamu,
HK Jan.
counsel for the petition. Mr. Arjun now on the action of Advocate General for respondent 1 to 7.
1 to 7, ma'am.
And Mr. A. Tata, the counsel for the respondent number 7. Who submits that this petition has become in process because the respondent number 8 has completed the execution of the work.
Yes.
And execution of the work. And the bill has also been paid.
Yes.
Okay. Okay, and the bill has also been paid by the responding authorities. Also, since the writ petition pertains to 2020, challenging the NIT
Yes, my
voted in the year 2020, Mr. Jama, non-counsel for the petitioner, has also not disputed that the writ petition may have become invalid. In view of the and as agreed to by the non-counsel for the parties, this writ petition is still closed as invalid.
obliged.
My lordship.
Ah.
Lordship, today I have filed rejoinder affidavit.
Hmm?
I have filed rejoinder affidavit.
Okay. What is the matter about?
Lordship. Reduction in the pay scale, lordship,
Reduction in pay scale.
after the department inquiry. lordship.
Okay. Mr. Ivan.
L1.
L1 counsel for the petition who submits that the rejoinder affidavit has been filed.
Also. Heard also Miss R. Vasavan Government. So some is, she has received a copy of the regional affidavit filed by the respondent, by the petitioner. Also, according to the council appearing for the parties, request for listing of this case after 4 weeks for admission hearing. As per listed after 4 weeks for admission hearing.
Okay.
My lordship, on last hearing, the counsel for respondents seek time to file their counter affidavit, but till date we haven't received counter affidavit.
They have not filed. What is the matter about?
Matter is related to mining, my lordship.
Matter relates to?
Mining, mineral mining, my lordship.
Huh?
Mining,
Oh, mining.
yes, my lordship.
Yes, Paulo,
We are yet to receive our instruction, your lordship. Some more time may be needed.
you have received instruction.
No, your lordship. Yet
How-
to receive your
How
lordship.
much time?
At least your lordship.
My lord, in this case, my lord, the petitioner, they're asking for a license from the deputy commissioner, my lord, which was turned down by deputy commissioner, basing on, my lord, some Guwahati High Court orders, my lord. Now, my lord, that case has been disposed of with the direction to the state government to make a rule, my lord. So rule has been framed the 2016, I think. Now, as per this rule, if the deputy commissioner is not issuing any license or not issuing the forms, and as per the section 20 something, there is an appeal provision also, he can still apply for that. Appeal provision is available.
What is that?
My lordship, in last hearing, they clearly asked for a time to file the counter affidavit, my lordship.
All right.
You are.
My lordship, and for arguments, matter may be fixed for another date because learned counsel is, leading counsel is not there, my lordship.
Okay.
She is out of station.
When do you want?
Yes, my lordship.
When? After 4 weeks?
My lordship, after 1 week, my lordship.
No, not after 1 week. You are what? If it is 4 weeks, we will send it after 4 weeks. You want a license.
Yes, my lordship.
You will apply under some rules before the deputy commissioner. Which rule?
My lordship, the leading counsel is not present today, my lordship, is out of station. Since
So
today
we
case
will
was
take
fixed for
sometime in
filing of
the-
counter affidavit, my lordship.
No, Ms. Navam is pointing out some appeal provision under the rules. If it is there, we will not.
Page number 130.
We will not entertain this state petition.
What is this?
You are not aware of.
Yes, my lordship.
Page 130. my
Since
lord, the
today case
petition.
was fixed for counter affidavit, my
130.
lordship.
Yes,
Para 80, your lordship. Section 80, your lordship.
that's it. Yes, license is granted under which rule?
This one is your lordship.
Hmm?
Section 80, your lordship.
No,
Appellate and
section 80 is
appellate.
appeal.
Yes, yes.
License is granted under which rules? Okay, let them file an affidavit.
Yes, my lordship.
Okay.
Yes, my lordship.
Miss, your good name?
My lordship, Tam Yaram. Tam Yaram.
Tam Yaram.
Yes, my lordship.
Miss Tam Yaram, Government Counsel for the petition. Miss P. Pangu, Government Advocate. Who submits that he is yet to receive instruction to file the counter affidavit for his request for and is granted further 2 weeks time to file counter affidavit. Listed after 3 weeks. Okay.
Hello, Bryce.
This is a matter of there is some urgency on behalf of the state. We are without a public service commission in view of an interim order passed by the division bench. And my lord, the understanding was that the matter will be heard and disposed of. And it relates to termination of members of the public service commission.
Termination of the members of public service commission or non-appointment of the
Recall of the appointment order.
recall of it.
It is, there was an order of appointment issued and that was recalled and that has been put to challenge.
Yes. Is the matter going to take some time?
And this will require time. That's what
Or-
I'm just
or-
discussing. with.
Is it a simple matter of non-appointment?
Well, this will
We
require.
are saying that in essence.
Non-appointment means denial of appointment. And denial of appointment cannot be made without an adequate reasons.
There are, well, let them address. I'll address your problem.
If the case is that simple.
It is likely to take some time, that is for sure.
Okay.
And I'm relying on quite a few judgments because it will I will take at least 1.5 hours time.
Okay.
My friend can complete, if necessary, my friend can complete his part today. I can continue, I can stay back tomorrow.
Sangeet
Yes,
is also
we are
there.
without a commission. So
Ah.
that necessarily means that we are not being able to undertake any selections.
My lord, as far as my lord,
Huh?
I am also appearing in item number 13.
there are
Ah.
two cases. Ma'am. Two persons were appointed and my lord, as far as urgency is concerned, my lord, even the petition also they want that they should be appointed as early as possible.
How many were appointed as members and chairmen along with both of you?
Two of us only as members.
Two of your members and one chairman.
And another member.
And another member.
One chairman and three members.
3
No,
members.
two, I think.
So chairman and another member is not before this court.
Yes.
So in the event they succeed, what happens to both of them? In the event they succeed, what happens to the chairman and one more member? I think the denial
No,
is.
third member is already there, I think.
No, she has been suspended.
Oh.
One member is there who has not resigned.
Or, okay.
That there is a further development in that. She has.
New appointment was only two of you. Four.
No.
One chairman and three members.
That is what Mr. Pangini is saying.
Yes,
That
exactly.
one member
See,
is not before this court
Yes.
And
and the chairman is not before this court.
Yeah.
So the question is, if they succeed, what will happen to that another member who is not before this court and the chairman?
There is no, I think there is no fresh harassment for chairman also.
Yes.
Although there is no challenge to the, it's a chairman appointment. Oh, so chairman,
General Santanu Doyan is the chairman and another Pradeep Lingpa, Professor Pradeep Lingpa who has not come.
chairman is not come.
Pradeep
Pradeep Lingpa.
Limpa. He was also appointed along with you as member,
Yes.
but not before this court.
Chairman is also not.
Chairman is also not.
So that way, even if the writ petition is immediately disposed of, immediately there is no question of.
If they succeed, there is a direction from this court to appoint. You may have to appoint them. Then what happens to this chairman and another member?
We will have to go ahead with the advertisement advertising. In respect of the chairman and the other member will go ahead.
Just because they are not before this court.
No, possibly, my lord, for the chairman, since there is no challenge to his cancellation, they could have easily advertised and they could have gone ahead with the appointment of.
That is what we did, my lord, and that has been said by the division bench.
Chairman.
In one advertisement itself, it's at page 105 of WPC number 213. The advertisement is in respect of chairman 1 post and members 3. But the interim order that has been passed, although it necessarily, if your lordship peruses the tenor of the language employed by the division bench, it is to protect them, the petitioners who are before the court. But the stay is of the advertisement itself. So therefore, if that much is clarified, my lord, at least we can still go ahead with the chairman and the other member.
Well, that may be clarified. We have, in fact, even before the honorable division bench there.
So how can this court clarify the order of a division bench?
That again is a problem. Your lordship is right.
My lord,
we're not there to do that.
In fact, my lord, my lord, I was present when the appeal was moved before the honorable division bench in Guwahati, my lord, the Honorable Chief Justice. There was no submission from the side of the state government that so far as the office of chairman is concerned, it should be kept open and we should be allowed to go ahead. That was not sought for. I was there, man. That could have been, because we could not have any objection to that. Our prayer is specific to our post, each of us. My lord, I'm also.
If I may place, our difficulty is, and what has fallen from your lordship is absolutely right. It will be perhaps not be proper even to
clarify.
But if your lordship will kindly have a look at the language of the division, what it says, may I read it to? In this view of the matter, it is hereby directed that until final disposal of the writ petitions, the writ petitions are only by these 2 members. Further process of selection of members of PSC as a consequence of the notification dated 28/4/23 shall remain stay. So in a sense, it can be interpreted to mean that this does not cover the chairman. And the 3rd member.
So that way they are free to go ahead with the selection of the chairman and
the moment
you seek clarification from the division bench.
If this is creating any confusion, that can always be got clarified.
That is one way of doing it.
And you go ahead with the selection of that chairman
and as well as the 3rd member.
As well as 1 member.
3rd member.
And another member is already there.
She has in the meantime been suspended in terms of Article 270. There's a presidential reference.
So the writ petition is also again anticipated.
It already, I am told, my lord, it has already been filed.
Notice issue? Yes. No stay?
No stay.
Notice issued mean it has to be heard.
It has to be heard.
One way of doing it is to get a clarification from the division bench. That is.
It is always better, my lord, because from our side, my lord, we will not have any objection. Even today we are clarifying.
Do you have any criteria for selection of chairman and members?
That is another. I have been informed that there is a PIL that has been filed saying that there should be a criteria.
Where?
Before this court, my lord. In fact, it was listed on the day I was here.
Is there is there any prescription with regard to the age?
Age is there, yes. Age restriction is there. Age.
Yes. Minimum age?
62. No, minimum is not there. Maximum.
That's what I'm saying. 21 can be.
My lord, in the two.
Hey, person as a 21 can also be appointed as a member chairman if he or she is imminent.
Yes.
And whatever is there.
But my lord, there are two Supreme Court judgments which my learned friend is also aware. Those two judgments of the Honorable Supreme Court have made it very clear that what are the criterion, integrity, etc. Everything has been clarified. There are two judgments.
But nothing about the age.
No. What I'm saying is, even the Supreme Court has gone to the extent of saying that if anything has to be laid down about their qualifications, etc., it has to be by the Parliament.
Now, so that is there,
My lord.
but all those qualities
My lord.
that the Supreme Court has laid down,
My
that
lord.
member of chairman should possess this,
My
this,
lord.
this. Are they capable of being attained by a person as a 21 or 25?
No, not.
You see,
Not
there
possible.
are big lacunas here. At
Look,
least,
my lord, with all respect, my lord, it is there in the Constitution.
Advertisement says below 62.
below 62, for a term of 6 years or 63, whichever is earlier.
My lord.
So it follows that 21, 25 can also be appointed.
Yes.
But under the normal
Impliedly.
circumstances where we see on the appointment of the various authorities, constitutional or otherwise, there are certain things
Yes.
that certain qualities for that. From age is also prescribed.
Your lordship
which
is
has
absolutely
some-
correct. My
which
lord,
has
the
some
kind of
reference-
experience the Honorable Supreme Court has said, the kind of experience one must have to man this office cannot be attained at the age of 21. Otherwise he is eligible. So these things are there, my lord.
So this is not free from difficulty. Issue on the basis of pleaded case may be very restricted.
But once
But there are
they-
a host of questions playing in the mind of, I think everybody.
Yes, that is the.
And those problems have been faced in various states.
Yes.
In fact, in respect of Punjab, I think
Yes.
my learned friend is referring to the Punjab judgment.
Punjab.
Those issues are,
Their BA LLB was held by the Supreme Court to not to be,
Sufficient.
not to be sufficient. Isn't it?
Yes, yes.
So it is-
Possibly in that case, there were
difficult area.
certain allegations also against him.
We
On-
consider
on a
BA LLB as to be highly eminent.
digressing slightly from this one.
Uh,
There is this series of entry tax cases that are coming up before the division bench there in Guwahati. While preparing, one Arunachal matter is also there. While preparing, I found an excellent sentence. In Sirbai, when Sirbai's constitution starts off with regard to Article 301, the first sentence is, the framers of the constitution have drafted a defective constitution.
That is why often we say our constitution is a dynamic one. So we'll go ahead with making research for further development.
So all in all, it will take some time.
It is likely, intricate constitutional issues are involved.
It will take some.
Various facets are there, my lord. All this will come.
I think you better seek some,
Clarification.
have a date of this case. So
Yes,
that-
yes.
And
Meanwhile,
think about the option which have seeking clarification from the division bench so that it is constituted, something like that. That is-
In that case, your lordship will just record that I have expressed extreme urgency. Your lordship will fix a date.
yes, yes.
I have expressed extreme urgency. Because of paucity of time, it has not been possible. Because
We'll what, fix a date or we'll say
Yes,
after
but your
2 weeks,
lordship-
3 weeks, something
My
like
lord,
your lordship will fix a date.
well, one aspect is there. The urgency is there, but immediately, even if it is disposed of, the commission cannot be made complete. Because they have to advertise, or if they want to go ahead with this advertisement, they will have to make the selection process complete. to
Chairman
appoint a
has to be there at least.
Chairman,
Chairman.
yes.
So
Without
this
the chairman-
advertisement, which is under challenge, as I said, the advertisement is for one chairman and 3 members.
Yes.
So if the division bench clarifies it, then what we can do is we can go ahead with the chairman and 1 member, and 2 we keep vacant for these
For
2
these 2 years.
petitioners. And that I am sure my learned friend also will not have any objection.
Today itself, I am saying I don't have any objection. Before
In that case, my lord, this case can be heard, my lord, because it is likely to take some time. That is for sure.
Yes.
So your
Well,
lordship will.
well,
If you are convenient with that.
And sometime in the 1st of August, first, second, any date, my lord.
31st of July. Monday.
Though Mr. I Chaudhry, learned Advocate General has expressed some urgency in the matter. Having heard the learned counsel for the parties.
Monday.
Problem.
Sunday.
Let this matter be
27.
listed on
এদিন দুদিন বেশি না ক্যালেন্ডারটা বলছো তোমার নয়
First of August.
ফার্স্ট উইকটা খালি আছে না নেক্সট উইকটা 7 তারিখ করে দিতে পারি সোমবার মানডে বুঝছি না বুঝছি না ইওর আর্জেন্সি আই আন্ডারস্ট্যান্ড আমিও তো বিস্তারিত শুনতে গেলে
Let it be 1st of August, if it is not inconvenient to my friend.
1st of August.
First of all, I got difficulties when 27th I have to come again. Couple of days thereafter coming again, slightly difficult man. 7th would have been a perfect matter.
7th will be little too late for me.
Yes.
But because the process which they will undertake now will take some time. There
Court
is
has no any issue. We can hear anything.
Yes.
Difficult. But on my side, I'll pray for 7th, my Lordship will kindly consider my. Otherwise, because this will take some time, once I come here, maybe for a couple of days, I will stay.
Seventh.
7th will be a little too long for me. I am under a lot of pressure.
My Lordship may mention that my learned AG has strongly prayed for an early date.
No, I've said.
Keeping in,
Recorded.
I'm very practical and keeping in view the steps which they will have to take, like filing an application for clarification, etc. 7th will not be very long date from my side, man.
7th and first only a matter of 1 week.
1 week, man. We'll finish, man. At one go, we'll finish. 7, 8, both days may be kept.
So in that case, it may be very clear that two, if necessary, 2 continuous days.
Yes.
7th and 8th.
Yes. I have no difficulty.
We'll leave that for the 7th court to decide.
And understanding is that if necessary, we'll continue till 8th.
This is the 7th.
But my urgency on my part may be recorded.
That may be right.
I've recorded.
Both the cases, 12 and 13.
Both.
Obliged.
Lordship,
Yeah,
here
madam.
case, Lordship, I have been suspended, Lordship,
Ah,
deemed suspension, Lordship.
good.
I was arrested and I was put under deemed suspension, Lordship. Order was passed. And now, Lordship, I've been released from the detention, from the jail. Lordship, neither they are revoking my suspension, neither they are extending the suspension order, Lordship. That is my case. Charge memo already they have served.
Yeah, madam, I need some time to file affidavit, madam, but
Last-
verbally, madam, I have instruction, madam, that departmental inquiry is going on, madam.
Okay, how much time?
2 weeks, my lord.
Okay.
2 weeks, my lord.
Lordship, last occasion instruction was to be sought, Lordship. Here in the case, Lordship, only instruction will be suffice the case, Lordship.
Okay, we'll see after 2 weeks.
Lordship.
Mr. J. is in the officer and Ms. He one government advocate. Request for and is granted for the 2 weeks time to file affidavit. Listed after 2 weeks.
Lordship.
Lordship, I am for the petitioner.
Yes.
May Lordship, I'm instructed to appear on behalf of respondent number 4, private respondent number 3. So I'm going to file my Bakalat Nama, Lordship.
What is this matter about?
This is regarding promotion of the post. The petitioner was serving as a LSC typist.
You are challenging his promotion, respondent number 4 promotion.
4 and 5.
No, Lordship. My promotion is not challenged, Lordship.
Okay.
Just made a party. on the basis of which structures, on the basis of claiming that he is the senior.
You represent four only,
Yes, yes.
not five.
Not five, Your Worship, four only.
What about five?
Five,
Service completed is regarding to the
yes, Your Worship.
respondent
Five,
note
no,
5.
Affidavit by the, you have in file.
yes, government affidavit.
Government has filed in their affidavit. The only remaining is respondent number 4 and 5.
4 and 5. Your Worship, for which time may be given, Your Worship, I will
Or
file.
Mr.
M. Tanga, Your Lordship.
M.
Tanga.
Tanga, learned counsel for the petition. Mr. Ms. K. Wama, learned dominant advocate, it will be responding 1, 2, and 3, who submits the counter affidavit by mistake. I will file. Mr. Diva, learned counsel. Submits that, have you filed?
No, Lordship, I am going to file, Lordship.
Submits that he has an instruction to appear on behalf of respondent number 4, for which he prays for, and is granted 2 weeks time to file. Wakalat number is always counter affidavit. This after 2 weeks.
Much okay.
Hello, very.
My lord, I have filed one IA in this case
Yes.
for permission to publish the notice in a newspaper by way of substitute service. My lord, in fact, I was granted permission in a previous hearing on 9th June 2023. But I have got permission from the registry that notice be published in the Arunachal Times. But the respondent number 3, she was deputy commissioner earlier, now she has been posted to Goa. So publishing the notice in a newspaper in our Arunachal Pradesh, that will not serve the purpose, madam. So I have filed an application for modification of the earlier order. And moreover, there are 4 more respondents, my lord. So I may be allowed to publish the notice in a newspaper in the places where they are residing.
One by one. You have filed 3 interlocutory applications.
Actually, I have filed 4. I have seen in the supplementary list only 3.
Only 3.
Yes, my lord.
Then where is the 4th one?
I couldn't understand why that has not been listed.
Then we'll list it on next day after tomorrow, along with that I.
All at depth tomorrow.
Number you have no.
Number,
I number.
I don't know.
Because of Mr. S. Cohen, learned counsel, submits the original care. He had no. Mr. S. Cohen, counsel for the applicants. All right, on the prayer of Mr. S. Cohen, counsel for the applicant, list it day after tomorrow. Day after tomorrow, we'll give the date.
All right.
Then that will automatically come.
Yes, ma'am.
In the IA 17. See, Mr. Cohen, day after tomorrow is what? Friday?
9th, 19. Just a second, madam. By Wednesday.
Or today 17. Okay. Okay.
Okay.
Lordship, here in the case, Lordship, respondent, in respect of respondent number 3, I have sought justice service, Lordship, last occasion. Yeah. Service report is still awaited, Lordship. I have tried to contact my client, to whom the copy was served to serve upon the respondent number 3, Lordship. And then
So you want some more time?
some more time, Lordship.
How much time?
3 weeks, Lord.
What Mr. Jason, my conspicuous and Mr. G. Additional Senior Government Advocate for the state. Mr. Jenny, Leonard Counsel for the petition submits that justice service upon respondent number 3 could not be taken as directed by this court on 24/5/2023, for which he pressed for and is granted how much time?
3 weeks.
For the 3 weeks time. Listed after 3 weeks.
Much.
Ma'am, my lordship,
Yeah.
this Mr. S. Kapilji is appointed. He had some personal work.
Okay.
So this matter is listed on 24th Monday.
24.
Yes.
Okay. That's good. Mr. K. on the conflict for the government of this on 24th.
Your Honor, I am for the respondent, what respondent? Yes, my lord, affidavit is ready, my lord, we are filing, my lord, it is in processing.
You are filing counter affidavit.
Yes, okay.
You have, okay, both the respondent,
Yes, my lord,
1 and 2.
yes, my lord.
When will you file affidavit?
Within today or tomorrow we will file.
Okay. Mr. H.K. Jano, council person, and Mr.
R. Riva, my lord.
R. Rival, council for the respondents 1 and 2, who submits that affidavit by the respondents 1 and 2 shall be filed within a day or 2. And I don't even press for listing of the case after 1 week, 2 week.
2 weeks.
2 weeks, 2 weeks. Yes, as preferred, listed after 2 weeks.
Obliged, my lord.
My lord.
Ma'am, my lordship, even this matter.
24, the same order, 24. As past in 21, huh?
Wait, please, Your Honor. My lord, here we had challenged the provisional land allotment order issued in favor of the Deputy Director of School Education, Papupara District.
Issued in favor of?
The Deputy Director of School Education for establishment of a school.
Okay.
I'm saying that this same land, my lord, this is, I've also been issued LPC, my lord. So, my lord, what I will pray now, my lord, is, my lord may grant me liberty to approach the secretary, my lord, in terms of the Arunachal Pradesh Land Settlement Act, section 83. My lord may close this matter by granting me liberty to approach the secretary.
Who was allotted earlier?
Allotment was done earlier to them. Thereafter, the same authority, my lord, they had also issued the land possession certificate after a year. The allotment is at page 29.
Page 29.
Yes, this is of 14 June 2005. What we are saying is this is different. And the land position is different. That's what I was saying. So there's some questions of factor there.
29.
Yes.
This is in favor of
The Deputy Director of School
Deputy
Education.
Director.
Yes. And my land position certificate is at page 26.
36.
26.
26.
$759 square meters, my lord.
Okay. See, he wants to approach secretary.
Yes.
Land management. What do you say?
I have no objection, Your Honor.
subject to. I may not be affected by that order.
Okay.
Yes, yes, I must-
Any stay order? No.
No. In fact, we had filed a suit here before earlier, before London trial court. Well, the suit was not even accepted, saying that this land allotment was issued under the 2000 Act. Was returned.
Okay,
That's why.
you must have contended that this allotment given to the deputy director
Yes,
is the same land which
Yes.
has been,
yes,
for which land possession certificate has been given to you.
yes,
But yours is a later in point of time.
yes, letter.
Okay.
That is the same authorities one.
And what have they say in their affidavit? What do you say?
We have said that, Your Lordship, the land falls under Durpang Reserve Forest, Your Lordship. This is what we have stated in our affidavit, Your Lordship.
Our-
This land, yes, Lordship.
Ah,
And even they
So,
can.
Your Lordship, this both,
whose land? His land?
yes.
Okay.
this
Then
land.
what about petitioner's land? Sorry, this respondent's land?
Same land, Your Lordship. So what we are saying that it is unauthorizedly issued both land allotment and
Both.
LPC. Yes, land allotment to the Director Education
All
and
that, then we'll close it, giving him liberty to approach.
Lordship.
Okay, Mr. Yadav?
Yes.
Yadav? Mr. Deepangu, counsel for the petitioner. Mr. R. Vasa, government advocate for, I think,
4 and 5, Your Lordship.
4 and 5.
Six,
Okay, and R.V. Yadav, government counsel for respondent number 6 and 7. None has appeared for respondents 1, 2, 3. And 8.
Gate.
Okay. So this writ petition has been filed challenging the provisional land allotment dated 14 June 2005 issued by the Deputy Commissioner Papumpare District UPA by number so and so at page 29 of the writ petition. However, the land mentioned therein has been provisionally allotted to the Deputy Director of School Education for Papumpare District UPA for establishment of government primary school at Lehi Village. And the writ petition has been contested by the respondents by filing a counter affidavit. Mr. Panging learned counsel for the petitioner submits that this writ petition may be closed with a liberty given to the petitioner to approach the secretary, land management, government of administrative projects. For ventilating the grievance of the petitioner.
My lord, in terms of the.
We'll say, let it. The said prayer of said prayer by the Lord Council for the petitioner having not been opposed to by our vessel and the government advocate as well as Mr. R.V. Other London Council for respondent number 6 and 7. This writ petition shall withstand disposal which is liberty granted to the with a liberty granted to the petitioner to approach the secretary, land management, government of administrative projects for redressal of the petitioner's grievance.
Public.